ಬರ್ತಾ ಇದೆಯಾ? ಬರ್ತಾ ಇದೆ.
ಕೋರ್ಟ್ ಆಫೀಸು ಕೋರ್ಟ್ ಆಫೀಸು ಇದು
ಸರ್ ಹೇಳಿ.
ಇದು ಬ್ಯಾಂಗ್ಳೂರ್ ಬೆಂಚ್ ಇದು ಫಸ್ಟ್ ಕರೀತಾರ?
ಅದು ಸಾಹೇಬ್ರು ಬಂದ ತಕ್ಷಣ ಕೇಳಿ ಹೇಳ್ತೀನಿ ಸರ್.
ಸರಿ ಸರಿ, ಥ್ಯಾಂಕ್ ಯು ಥ್ಯಾಂಕ್ ಯು.
ಅವ್ರ ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಇದೆ, ಅದಕ್ಕೆ ಅವ್ರಿಗೆ ಟೆನ್ಷನ್. ಎಲ್ರಿಗೂ ಅವ್ರವ್ರದೇ ಟೆನ್ಷನ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಇದೆಯಲ್ಲ ಅದಕ್ಕೆ.
ಹೌದು ಸರ್.
ಮೇಡಮ್ ಇದು CS ಇಲ್ಲೇ ಬರುತ್ತಾ? ಇದು ವಿಡ್ರಾಲ್ ತಗೊಂಡ್ಬಿಡಿ ಮೇಡಮ್. ನಾಳೆ ಕೊಡ್ತೀರಾ ವಿಡ್ರಾಲ್?
ಪೆಟ್ರೋಲ್ 230 ತರಿಸ್ತೀವಿ.
ಏ ಬೇಡ, ನಾವು ಮನೆಗೆ ಹೋಗಿ ಬೆಳಗಾಂ ಹೋಗ್ಬೇಕು. ಮೇಡಮ್ ಯಾವ ಕೊಡ್ತೀರಿ ಮೇಡಮ್ ರೀ?
ಹಲೋ
ಮೇಡಮ್, ಇದೊಂದು ಫಾರ್ ಕರೆಕ್ಷನ್ ಆಫ್ ಆರ್ಡರ್. ಕರೆಕ್ಷನ್ ಅಯ್ಯ ಹಾಕ್ಯಾರ ನಾಡ್ದ 31st.
That maid came and bought.
ಇದೊಂದು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮಂಡೇ. ಇಲ್ಲ, ಇದು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ನಾಳೆ ಕೊಡ್ತೀವಿ. ಕವರ್ಡ್ ಬೈ ಜಡ್ಜ್ಮೆಂಟ್. ಮೇಡಮ್ ನಾಳೆ ಸಿಗ್ಬೋದಾ? ಪ್ರೆಷರ್ ಎದೆ ಮಾಡಿದ್ದು ಮೇಡಮ್, ಇದೊಂದು ಥರ್ಡಿಗೆ 2022 ಮ್ಯಾಟರ್. ಈ ಒಂದೆರಡು ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಐಎ ಹಿಯರಿಂಗ್ ಯಾವಾಗ ಕೊಡ್ತೀರಿ? 3rd 4th ನೀವು ಮೆನ್ಷನ್ ಮಾಡ್ಕೊಡ್ತೀರಿ.
ಕೊಡಿ. ಗೆಸ್ಟ್ ಲೆಕ್ಚರರ್
ಗೆಸ್ಟ್ ಲೆಕ್ಚರರ್ಸ್ ಎಲ್ಲ ಕೊಡಿ 2:30. ಯಾಕೆ ಮೈಕ್ ಕಿವಿಗೆ ಇಟ್ಕೊಂಡು ಮಾಡ್ತಾರೆ ಬಾಯಿಗೆ.
2:30.
Ah.
The election matter and CRC BRC is prohibited to contest the election. Kindly.
CS RES ಹಂಗಂದ್ರೆ ಏನು? Pertaining to society what? ಆಯ್ತು ಕೊಡಿ, ನಾಳೆ ಆಗ್ಬೋದಾ? ನಾಳೆ
That's one Bangalore bench matter. Anytime next week.
ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ.
That's one.
Thursdays Bangalore bench matters.
That's
1:00. ಓಯ್ ಏನ್ ಮುಹೂರ್ತ ಕೇಳ್ಕೊಂಬಂದಿದ್ದೀರಾ? 1:00ಗೆ ತಗೊಂಡ್ರೆ ಸ್ಟೇ ಕೊಡ್ಸೋದು. ಹಾ.
On the interim application, what main prayer is also saying, your lordship, the petition is filed on the.
AG ಸರ್ವ್ ಮಾಡಿ ಕೊಡಿ. ಅಷ್ಟ್ರಲ್ಲಿ ಈಗಲೇ ಸರ್ವ್ ಮಾಡಿ. ಗೆಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್. 2:30ಗೆ ಯಾಕೆ ಆಗ್ಬಾರ್ದು? That's okay.
Lords, this is one matter where I am appearing for the bank, my lords. At the instance of proceedings initiated by the debtor, proceedings are stayed before this honorable court. Award has attained finality. All collateral proceedings.
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ?
I filed application seeking permission to deliver possession to the auction purchaser.
That's
May I request on Monday, my lords?
Monday.
Lords, this is another matter, surfacey matter. I've sought for extension of time to deposit.
Monday.
Please.
Permission. Serial number 60. Now becoming source note.
Thank you. Serial number 60. 60.
60.
All right. Yes.
What happened, my lord? Your lordship given date.
What happened ಇಲ್ಲ ಏನ್ ಹೇಳಿ?
One Bangalore matter, my lord. Last week I moved it, my lord. Your lordship given today, my lord. The file could not reach to Dharwad. Yesterday it
ಬಂದಿದ್ಯಾ?
came to, my lord. It has
2:30
come, my lord. Any date after 4th, my lord.
4th.
February.
ಅಲ್ಲ 6th. Next date is 6th Thursday.
Please. RP Somsekhar, Bangalore.
ಏನಾದ್ರು ಒಟ್ನಲ್ಲಿ
Please.
6th. Yes. Fresh matters. Dharwad. Fresh matters. Second list. Principal. ಎರಡು. I'll finish fresh matters of Dharwad and take fresh matters of
My lord.
Bangalore bench.
Bangalore
Yes.
bench matter.
Wait, I'll
My lord,
finish fresh matters of Dharwad and take fresh matters there. Yes, next.
36, 37, 38, 39 and 40.
Madam, ಒಂದ್ಸರಿ 4 ಸರಿ ಬರ್ತಾ ಇದೆ.
ಇಲ್ಲ ಅವರು ಇದು ಮಾಡ್ಬೇಕು ಸರ್, ನಮ್ದ್ರಲ್ಲಿ ಇದೆ ಅಲ್ಲ ಬೇಕಾದಾಗ ನಾನು ಅದಕ್ಕೆ ಎರಡು ಕಡೆನೂ ರನ್ ಮಾಡ್ತಿದ್ದೆ, ಅಲ್ಲಿ ಇದಾದ್ರೆ ಇಲ್ಲಿ ಬರಲ್ಲ. ಇಲ್ಲ ಅವ್ರು ಮಾಡ್ಕೊಳಲ್ವಂತೆ, ಆ ಕಡೆ ಹೇಳಿದ್ರು ಮಾಡಲ್ಲ. ಈ ಕಡೆನೇ ಇಟ್ಟಿರ್ತೀನಿ ಸರ್, ಈ ಕಡೆನೇ ಈ ಕಡೆನೇ ಇಟ್ಟಿರ್ತೀನಿ.
Unmuted. ಇಲ್ಲಿ ಹಾಗೆ ಇಲ್ಲಿ.
ఈడే కొంచెం మరి ఈడే ఉంది అడిగిన ഇന്നലെ అడిగినా ముందు వచ్చావు తల తిట్టావు వాళ్ళు లేచి చేపలు చెప్తాను తల తిట్టావు వచ్చా పుండో మేడం
Nomination rejected and you have to go.
My lord, what happened, my lord? I have given representation, man. The matter may be disposed of.
A direct consideration of that representation.
Otherwise, it will become infructuous, my lord.
Yes.
Tomorrow
I'll put madam. ಇನ್ನೆರಡು ಶೇರ್ ಆಮೇಲೆ ಮಾಡ್ತೀನಿ.
Please.
21 year olds ಇದೆ. So he has given a report.
No, 1 minute. I'll take that list and finish.
Yes,
Fresh
sir.
matter ಆದ ತಕ್ಷಣ ವಾಪಸ್ ಇಲ್ಲಿಗೆ ಬರ್ತೀನಿ.
ಅಲ್ಲ ಅಂದ್ರೆ I need some time, your lordship. Tuesday. Yes, your lordship.
1 minute, Jagdish Patil.
Yes, sir.
the petitioner is before this court seeking the following prayer. DJ Nayak kadena?
Yes, sir.
The learned counsel for the petitioner would restrict his prayer for a direction to consider the representation that he has submitted in terms of annexure A. The representation,
Annexure C, my lord.
annexure C.
Page number 15.
It is the case of the petitioner that his nomination has been rejected erroneously. And therefore, before the date of the election, his representation needs to be considered. In the light of the said circumstance, I deem it appropriate to direct which respondent?
Respondent 4, my lord.
Direct respondent number 4 to consider the representation of the petitioner.
R5, respondent 5, my lord.
R5 to consider the representation of the petitioner as found at annexure D.
C.
D na?
Your lordship.
Order passed in annexure D.
It's a D.
Annexure D, my lord. Endorsement.
Washing of annexure D, your lordship here.
ಈಗ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಕೊಟ್ಟಾಗಿದೆಯಲ್ಲ ಇನ್ನೇನು?
My lord, there are two nominations, my lord. In B group, they have filed the nomination, that is considered. I have filed application to consider the general category. Because last time I am elected in the general category.
Learned counsel would submit that what has been considered and rejected on 26/1/2025 is the nomination filed as a category, another?
B category, OBC B.
B category. And the present representation is preferred, seeking to consider the nomination of the petitioner that is filed in general category.
General category.
Therefore, the respondent shall consider the representation and pass necessary orders in accordance with law before the date of the election.
Please.
Ordered accord.
Second is the date of election. your lordship.
Hand delivery.
Final order hand delivery na.
ಅಲ್ಲಂದ್ರೆ ನಾಳೆ ಇದ್ ಮಾಡ್ತಾರ ಅವ್ರು.
ಅಂದ್ರೆ ಸಾಯಂಕಾಲ ನೋಡ್.
2 days.
ಅದು ಇನ್ನೆರಡು ಬೇಡ.
As pertains to.
Serial number 1 and 2, 1 and 2 second.
ಮಾಡ್ತೀನಿ. ಅದೇನು ಅರ್ಜೆನ್ಸಿ ಅಂದ್ರೆ.
Number 1.
ನಿಮ್ದು ಶೇರ್ ತಾನೆ.
Please.
ಆಮೇಲೆ ಮಾಡ್ತೀನಿ.
Serial number 3 and list number 2.
ಆಮೇಲೆ ಮಾಡ್ತೀನಿ.
Serial number 1, Rahmatullah Kotwal.
Appearing for the petitioner, your lordship, in this case.
ಯಾಕೆ ಹಾಕಿದ್ದೀನಿ ಅಂತಾನೆ ಗೊತ್ತಿಲ್ಲ. Complainant is not heard in the matter.
The complaint is the state, your lordship.
No. There is complainant ಇನ್ನೊಬ್ರು ಇದಾರಲ್ಲ.
Being spoken.
ಗೊತ್ತಾಯ್ತು. Complainant ಇನ್ನೊಬ್ರು ಅದಕ್ಕೆ ಹಾಕಿದ್ದು. The order is ready, but I then saw the complainant is not a party. Complainant is not a state, sir. The subject petition was heard and disposed by its order dated 5/11/2024. Before the order could be signed, it is noticed that the complainant, the de facto complainant, was not heard in the matter.
Lordship, I'll issue notice once again, your lordship.
Notice ಎಲ್ಲಾಗಿದೆ. This the matter is not, therefore, issue notice to the second respondent complainant returnable by the 7th March 2025.
Your lordship, till then interim order may be kindly.
Yes, sir. The 7th March 2025. List the matter on 7th March 2025 for the hearing. There shall be an interim order of stay till the next date of hearing. Next.
Much obliged, your lordship. Let's do one more submission, your lordship. Then accused number 1 and 5 to 6, 7 are acquitted.
We'll see. Yes, on that day.
Please,
Next.
please, your lordship.
Praveen,
KPID. Accused number 4.
Praveen alla, sir. Accused number 4.
Yes, my lord.
ಯಾರಿದ್ದಾರೆ? ಶರತ್ ಚಂದ್ರ. ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ. Anyway, you take notice. There are direct allegations here at page 50.
Yes.
Learned additional SPP is directed to accept notice for the first respondent, emergent notice to the second respondent returnable by the 7th of March. List the matter on 7th of March 2025.
Bill number 3, Praveen is.
Yes, Praveen.
Chip.
What lorries?
420 read with 34 of IPC.
All right, Praveen, what lorries had to be given?
My lordship, these are Ashok Leyland lorries. I have delivered it to the purchasers, my lordship, respondent 2 and 3. However, there is some dispute between the accused number 2 and the respondents, my lordship. The lorries are delivered from my side. It is registered. In fact, the complainants have to come and make the necessary signatures to get the RC card, my lordship. They have also done it. There are no explicit allegations in respect
The
of
learned counsel Praveen C. appearing for the petitioner. The learned additional SPP is directed to accept notice for the first respondent. The issue revolves around a transaction for delivery of lorries from the dealer, i.e. the accused number 3, the present petitioner. The learned counsel Praveen C. submits that what the petitioner had to deliver after the receipt of the money has all been done and all necessary documents are executed by him. The dispute between accused number 1 and 2, accused number 1 and 2 with the complainant has driven the petitioner into the web of proceedings. In that light, there shall be an interim order of stay till of further proceedings, quay the petitioner till the next date of hearing. Emergent notice to respondents 2 and 3 returnable by 7th. List the matter on 7th.
My initials are Praveen S, my lordship. My initials are Praveen S. Praveen C and Risami.
Oh, Praveen S. Sorry. Yes.
Like my lordship.
Bill number 4, Madhu CA.
For petitioners in this case, my lord.
Come to page 48, sir.
Please, my lords.
Very difficult.
Please, my lords. My lords, petitioner number 3 and 4 are residing separately, my lords. Sister of petitioner number 1, my lords. Brother-in-law of petitioner number 1, my lords. They are residing 40 kilometers away from the place, my lords.
40
kilometers away from the place.
Which place?
Place, my lords. 3 and 4. Petitioner number 1 is the son. Petitioner number 2 is the mother, my lords. Mother is suffering from spinal cord problem, my lords.
Bail kottidharalla iga.
Bail ide Swami. My only submission is just to harass the petitioner. This complaint has been filed, my lords.
Page 46. Accused number 4 ಮೇಲೆ ಕಾರ್ ಗುದ್ದಿದ್ರು ಅಂತ.
Accused number 4 ಮೇಲೆ
ಪನ್ನು ಮತ್ತೆ ಕಾರ್ ಇಬ್ರು ಸೇರ್ಕೊಂಡು ಕಾರಿಂದ ಕೆಳಗಡೆ ಗೆಳೆದು. Page number 46.
ಯಾವ ಕಾರಿಂದ ಎಲ್ಲರೂ ಸೇರ್ಕೊಂಡು ಕಾರಿಂದ ಇಳಿಸಿ ಹೋದ್ರು ಅಂತ ಹೇಳಿದಾರೆ. ಎಲ್ಲ ನಿಲ್ಲಿಸ್ಬಿಟ್ಟು ವಾಟ್ ಸರ್.
ಸ್ಪೆಸಿಫಿಕಲಿ ಆನ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಮತ್ತು 4 ರವರು ದಿನಾಂಕ 12/8/24
Yeah, all these stories.
The petition for restitution of
line bitre page 48 ಅಲ್ಲಿ ಏನು ಇಲ್ಲ.
Please,
the petitioners accused 1 to 4 are at the doors of this court calling in question proceedings in so and so CC zones. A perusal at the summary of the charge sheet as obtaining in column number 17 would indicate no offense or no ingredients of the offenses alleged against these petitioners, which are for offenses punishable under section 498A 323 and Dowry Prohibition Act. The dispute between the husband and the wife with regard to happenings of a daily family life is projected to become the ingredient of the offenses. The complainant herself narrates that several talks of settlement or mediation failed, and therefore the complaint comes to be registered. In such cases, if further trial is permitted to be continued against these petitioners, it would run foul of the judgment of the apex court in the case of Kashkan Kosher versus so-and-so 2022 SEC online SC page 162, insofar as the other members of the family is concerned. Insofar as the husband is concerned, if further proceedings are permitted to be continued, it would again run foul of the judgment of the apex court in the case of Achin Gupta versus so-and-so 2024 SEC online SC page 759. Therefore, there shall be an interim order of stay of further proceedings quay these petitioners till the next date of hearing. 1 additional SPP 2 emergent notice returnable by the 14th of March. List the matter on 14th of March.
Great.
Bill number 5.
Yeah, for
Girish, please.
petition, the petition is accused number 12. For the offense registered under section 143.
302, sir.
Not 2 minutes. The allegation against the present petitioner
No, no.
is
Sir.
residing in the rented house of belongs to the accused
Are
number.
residing in the rented house, come to page 74, sir.
Tave one judgmentally connected accused have
Dismiss
argued in
ಮಾಡಿ.
length and they sought for permission to file a discharge application and that is pending
Like
before the
connected the petition with respect to the accused number 17, which is pending before your lordship in writ petition 4021/24. That is pending before your lordship.
Discharge ಹಾಕೊಳ್ಳಿ.
Like the only allegation that he is not
No.
the conspirator or only conspirator is accused number 2 to 9.
ಅಷ್ಟೇ ಇದ್ಬಿಟ್ಟಿದ್ರೆ ಬೇರೆ. Come to page 74, second paragraph, 6th line. Yes.
and in earlier case she is also an accused in that case where they have that
No, sir. ಕೇಸ್ ಇದ್ರೆ ನಾನೇ ಕೊಡ್ತೀನಿ. ಗಿರೀಶ್, discharge ಹಾಕೊಳ್ಳಿ.
Permitted to keep open all the contention raised.
Everything open. Yes. The learned counsel with the petitioner, after arguing the matter at length, would seek leave of this court to avail the remedy of filing a discharge before the concerned court. All contentions remain open. Yes, next. The aforesaid observations, petition stands disposed.
6. Raman Nalina Lingesh.
I appear for petitioner, my lords, in this matter. I pray for some time. I need to produce few documents.
Bagarukum.
This is with
Huh?
respect to the
Bagarukum.
ಗೊತ್ತಾಯ್ತು, ಬಗೈರ್ ಹುಕುಂ. ಅದು accused number 1.
My lords, this is
This petition won't go anywhere. I will not grant bail.
my lords, I produce few documents. Few documents are extremely necessary on how
All
what
right, last time ಅದೇ submission ಮಾಡಿದ್ರಿ.
I'll produce. I have sought for the documents. If my lords, would
ಬಗೈರ್
like-
ಹುಕುಂ committee acting ಬಗೈರ್ ಕಾನೂನ್. Yes.
my lords, sometime in March, my lords, in the 3rd week, I'll produce the documents before.
All
that.
right, list the matter on 7th March. ಇವೇನೇನು ಮಾಡೇ ಇಲ್ಲ. Anticipatory bail.
Correct. I have the inspector said,
Because he is former MLA, ಏನು ಮಾಡಿಲ್ಲ.
apparently Tashildar said that it is Tashidar's responsibility.
No,
not- I
no,
said he get the
Chairman
records.
of the committee. Yes.
I've asked him to get the records.
7th March. Yes.
Grateful, grateful.
7. Pravinis.
Offense of 306 of IPC, my lordship.
Praveen,
My lordship.
come to page 33.
Yes, my lordship.
Little difficult because it is 306.
My lordship may peruse ink
Hmm.
page 122, my lordship.
Yes. You had an
122.
you had an affair with her.
No, she was fiancé, my lordship.
Whose fiance?
The petitioner and the deceased were fiancés, my lordship.
No,
The petitioner was a fiancé.
earlier relationship was
She was divorced, my lordship. She was divorced from
Ah.
her previous husband, my lordship. Page number 122, my lordship, are the messages she has sent the petitioner. This is a part of the charge sheet, my lordship.
122
number
ಒಂದೇ page
122.
WhatsApp.
How this one? My lordship may peruse. This is just before she commits suicide, my lordship. She messages. He asks her, did you reach safe? She says, yeah, thank you. She says, I'm sorry. He says, don't be sorry. You take care, baby.
Even the
Call me
death
when
note
you
does
can.
not name him.
My lordship?
The earlier frustration of the earlier relationship is carried on.
No, my lordship. Her mother had passed away, my lordship, and she was in depression. My lordship may look at the death note, my lordship. I'm relying entirely on the death note. 153, my lordship.
But ಅದೆಲ್ಲ matter of evidence ಆಗುತ್ತಲ್ಲ.
How this, Swami? My lordship, the only contention I'm telling here, my lordship, is that the respondent number 2 did not approve of the relationship with the petitioner, my lordship. And the moment she passed away, all he states is that there is some dispute between my deceased sister and the petitioner, my lordship. My lordship may peruse a writing in 153, my lordship. That's a death note. It says, I don't want to be here anymore, Senthil. Senthil is a nickname of her brother. She says, I love you. I'm sorry. I'm depressed, she says. I can't deal with life anymore, she says. She says, Atul is the petitioner herein. I'm sorry for everything. I really love you. This is just before she passes away, my lordship. She says, but I can't do this anymore. She says, I don't understand that part of this, my lordship. But then she says, I wish all of you, Senthil, Atul, my entire family, but I went for you. I want to know that I dearly love you. She names all her colleagues, all her friends, and she says, forgive me. There is no case that, he abetted any act or any overt act that resulted in her suicide, my lordship. The only factor here is that, my lordship, the brother of the deceased did not approve of the relationship with the petitioner here in my lordship. And
Who
the
is the
moment he
complainant?
passed,
Complainant is the brother?
the complainant is the brother, my lordship.
The petitioner is the sole accused. In a proceeding in CC 67846 of 2024, registered for offence punishable under section 306 of the IPC. Section 306 of the IPC should necessarily have its ingredients as obtaining under section 107 of the IPC for it to become an offence of abetment to suicide. The issue in the list is with regard to the sister of the complainant, now deceased, and the petitioner being in love. The complainant, the sister of the complainant, who was earlier in a relationship, had earlier married,
Earlier married, my lordship, and divorced.
earlier married, had divorced in the year 2022, after which the petitioner and the sister began to live in together. The learned counsel, Praveen S. Yes.
Yes,
Praveen S. takes this court through the death note as also the statements recorded at the time of investigation, a perusal of which would clearly indicate
Page 154, last
150.
154. No one is responsible for my death.
ಅದನ್ನ ಹೇಳಕ್ ಹೋದ್ರೆ ಆಮೇಲೆ evidence. The death note is indicative of the fact that also takes this court through the death note, which does not pin down the petitioner for the aforesaid offences. The crime appears to have been registered only to assuage the feelings of the family of the deceased, which the apex court clearly holds that it should not be done in a judgment rendered in reported in 2025 SCC online SC page 106. As also the judgment again reiterating the earlier observations in 2025 SCC online SC page 120. Therefore, permitting further proceedings against this petitioner in the teeth of the aforesaid facts would run foul of plethora of judgments rendered by the apex court. Therefore, there shall be an interim order of stay of further proceedings qua this petitioner till the next date of hearing. One additional SPP, 2 emergent notice returnable by 14th March, list on 14th March.
Pledge, my lordship.
Bill number 8, Siddharth Suman.
Please, my lord. Mr. Nawadgi is appearing
Lords,
through
in
video
this matter, Lords.
Oh, SPP is here. Yes.
ಇದರಲ್ಲಿ CV Nagesh sir had appeared before your lordship.
All right.
ಅವರು ಮತ್ತೆ he had requested me, my lord, that ಈ ಸ್ವಲ್ಪ article 194 ಎಲ್ಲ ಇದೆ, if I could assist the court ಅಂತ. Therefore I am here.
Yes,
my lord.
yes.
If lordship permit me, I'll just
Finish it today. Yes.
please. Lords, the primary contention which has been raised before your lordships is that the registration of the criminal case, my lords, comes in conflict with the lords,
Parliamentary privileges.
yes, the
Yes.
privilege and the specific bar as it's contained under Article 194, subclause 2.
Yes.
And may I take lordships to Articles 194, subclause 2?
Constitution. Yes, ಹೇಳಿ sir.
Lord, 194 subclause 2 Lord, appears in the chapter powers, privileges, etc. of the House of Legislatures and of the members and committee thereof. 194(2), my lords. No member of the legislature of a state. Lordships get 194.
Yes, yes, sir.
I'm sorry. No member of the. Please.
No, I'm all ears. Yes.
No, I'm just. No member of the legislature of a state shall be liable to any proceedings in any court in respect of anything said. Well, this is what is the emphasis, Lord, which we want to place before your lordships.
Yes.
Or any vote given by him in the legislature or any committee thereof, and no person shall be so liable in respect of the publication by or under the authority of a house of such a legislature of any report, paper, votes, or proceedings. But I also want to read subclause 3 for the purposes of bringing to Lordship's notice that subclause 3 is something different from subclause 2 and how the Honorable Supreme Court makes a distinction between subclause 2 and subclause 3. For that purpose, I also want to read subclause 3. In other respects, that is, except for anything said or vote given, the powers, privileges, and immunities of a house of the legislature of a state and of the members and the committees of a house of such legislature shall be as such as may from time to time be defined by the legislature by law, and until so defined shall be the house, shall be that house and its members and committees immediately before the coming into force of the Section 26 of the Constitution, 44th Amendment, Act 1978. But subclause 2, as Lordships have seen, completely gives, what I will use the word immunity, for any member of the legislature of a state regarding two actions. One is, for anything said in the legislature or for any vote given in the legislature. But it is it is not in dispute now that the registration of the case against me is in respect of something alleged to have been said by me in the legislature. Please. If the version of the police, which is the first information report, is taken, or the complaint or the first information which was given is taken, it comes in conflict with subclause 2. But I must, of course, meet before bring to Lordship's notice that this incident also was taken cognizance by the chairman of the Legislative Council. There was a complaint given by the learned member, that is the respondent number 2 before your Lordships, before the speaker, making the same allegation. Then notice was issued to me by the chairman.
If your Lordship is finally hearing, complainant is a party.
Who is the complainant? Oh, correct. Complainant is a party. Yes. Notice Madila last time.
Notice Madlila.
Panindra appeared. Mr. Panindra appeared. Mr. Panindra appeared. You're
right. Sir.
Please. There was
yes, sir.
Yes. The Honorable Chairman of the Karnataka Legislative Council took cognizance of this incident. Complaint was filed before him. Then, he issued notice to the petitioner and gave a ruling. A decision was given by the Honorable Chairman of the Legislative Council. Lordships may kindly take note of this aspect.
Yes, sir.
Please. Please. But these are, according to me, the two broad factual foundations which would give rise to certain questions of law, which hitherto have really not been decided by this honorable court. But apart from this narrow issue of a complaint filed by the respondent.
Lakshmi Hebbalkar is the complainant.
Yes.
Yes.
Please, ma'am. But these are the two broad aspects, factual aspects, on which several questions of law would arise for Lordship's kind consideration. Except for one or two cases, by immediate reference, not many judgments are there of this honorable court, which decides. This honorable court, A.K. Subbaya adanta reference ಮಾಡ್ತಾರೆ, but I am not very sure.
Not on this context.
Please, adu bitre, there is no other decision of this honorable court on this issue. But I'll broadly summarize before your Lordships what could possibly be the issues which would it very scary. You late Siddharth, with sorry, I'm Nagesh, but I will still not make an effort. I do not want. In fact, I wanted to come physically to address your Lordships on this question because the chairman of the Legislative Council I'm sorry, chairman of the legislative
Raja
council.
Rampal yake?
Raja Rampal ide. I'll broadly first summarize before your lordships what would be the possible issues which would arise for lordships' kind consideration. In fact, the chairman of the legislative council also, I may state before your lordships, was also vitally interested to bring to the notice of the court as to what would be the issues. The issues would be something like this. Number one would be having regard to the I'm told contentions raised by the learned SPP. What is the protection to a member of the legislature of the house in respect of anything said by him?
Yes, sir.
In the legislature, that is, whether the precincts, what exactly would be the precincts of the legislature? Would it include even when the chair, even when the chair is not presiding over the session? This will be the first question, having regard to the contentions raised by them. Secondly, and very importantly, according to me, once the same issue has been taken cognizance by the legislature itself, and a decision to that effect has been pronounced, would it be open for an authority like the CID or the police authorities, which basically would represent the executive, to revisit that incident?
No, this is with regard to a particular incident.
Please.
But on a broader perspective.
Please.
Okay, broader perspective.
I can, please.
The issue needs to be decided with regard to can anything be spoken, done in the legislature which has no nexus to the issue that is discussed in the legislature?
Yes.
We said that there is immunity.
Correct. The answer seems to be, on a face of it, lordships may feel that what is not connected with the house, how can it be considered?
How can the statement that is made by the petitioner have any nexus or connection to the proceedings of the house?
Correct. Of course, we have denied that the statement has been made. Anyway,
denial is a different thing.
Assuming that something to that effect is there, what is the extent of protection given?
Judgments ಏನಿದೆ?
ಇಲ್ಲ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ನನಗೆ.
ನೀವೇನ್ ತಂದಿಲ್ವಾ?
ಇಲ್ಲ ನಂದು ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದರೇ ರಿಲೇ ಮಾಡಿ.
ಸೀತಾ ಸೊರೇನ್.
ಇಲ್ಲ ಆ ತರ ಸುಮ್ಮನೆ ಲಾಸ್ಟ್
which is referred there.
Nobody has done the homework.
Yes, Lord, mine is there.
What?
ಅಲ್ಲಲ್ಲ ಅದನ್ನೇ ಮತ್ತೆ ಇನ್ನೊಂದು
also placed 1951 Calcutta High Court judgment.
Nexus test is not what I am saying.
Yes, Lord.
It's the.
May I complete?
Yes,
may I complete? ಅವ್ರಿಗೆ ಹೇಳಿ ಪರವಾಗಿಲ್ಲ. Mr. Belliyappa, let him throw some light note on this subject.
Yes, sir.
But I'll just bring to lordships notice whatever has been my research. The fundamental question, whether it is connected to the proceedings or not, would seem to have been dealt with by the Lord's judgment in Sita Soren as well as in Raja Rampal's case. I must bring to lordships notice. May I request first lordships to kindly see the commentary on Erkin's on parliamentary practice note. Erkin's May on parliamentary practice. There's a photocopy. But I have given a photocopy. No. Extract. Yes.
Yes, sir.
Now, lords, this, lords, I must bring to lordships, and lordships are aware. This Erskine May's treatise on the law, privileges, proceedings, and usage of Parliament, the first page, Lord. This has been very frequently referred to. Frequently referred to by the Honorable Supreme Court and considered an authority. May I request lordships to kindly see page 87 in this note, the next page.
Yes,
Criminal words in Parliament.
Yes, sir.
It may be regarded as established that a member is not amenable to the ordinary courts for anything said in debate, however criminal in its nature. The language of Article 9 of the Bill of Rights is designed to make this clear. Except by some forced construction, words spoken in debate cannot be taken out of the category of proceedings in Parliament. the principle is also established by the decision of the House of Lords in reversing the condemnation in the King's Bench of Sir John Eliot and his fellow members on the ground, partly, the speeches of whatever character be made in Parliament could not be inquired into out of Parliament. Then, my lords, the commentary goes on to say any other criminal act cannot be outside the, can be inquired into by the lords, ordinary criminal courts. But what is important here, lords, in answer to lordship's query is 194 subclause 2, lordships have seen it.
Yes.
No, does not make a distinction that it should be in connection with the debate or the proceedings. It simply gives us protection for anything said or vote given in the legislature. Lordships could also see.
Yes. Yes, sir.
Great. Lordship could also see 194.2, in fact, also includes my participation in a committee also. If I had said anything in a subcommittee's proceedings also, I am protected. The question of, therefore, lords, importing this principle that, lord, this anything said by me only in the course of a debate or a parliament is protected and not anything else is something, lords, which my respectful submission to your lordships is 194.2 does not contemplate. 194.2 does not contemplate a situation at all. It simply gives protection, my lord, for anything said or a vote given in the legislature. It does not say, for instance, to say anything said in the course of the proceedings. The word in the course of the proceedings is, my lord, conspicuously absent.
Yes, sir.
Yes, my lord. Therefore, my lords, what according to me 194.2 the object seems to be is to give that blanket protection to a member of the House.
Yes, sir.
For any action by him, any word said to any word spoken by him in the House, legislature of the House.
Yes.
But if this argument was to be taken that it is only in the course of the proceedings, then the word committee would not have occurred in 194. Lordships have seen 194.
No, that submission I did not accept earlier.
Please.
That whether the House is in session or not, the immunity, yes, is there.
Correct.
But that immunity is a qualified immunity. Not a blanket immunity.
There is a reason.
Prima facie view. Not,
I understand. That's a doubt, Lord, which has occurred in the court's mind, but we are bound to answer that. But according to 194.2, 194.2, according to me, Lords, is a sort of a shield, Lord, to the member of the legislature, because he must be expected to speak fearlessly, and without any threat of being prosecuted outside.
True.
I'll give an example.
One moment, sir. Speak fearlessly anything?
I'll give an example.
Like the thing that is allegedly spoken now.
I'll answer that question. Nobody can speak anything, obviously not. The question is this, if somebody speaks something, which is a libel, slander, defamatory. Let me take this example. But forget this incident. Tomorrow, a member of the House may speak something very vociferously against the Honorable Chief Minister itself on the floor of the House. Assuming, let us say, he speaks what is the remedy? The question. Lord, what the House has done is, if you do something within the House, the courts will not look into it. It is for us to look into it. That is the thin line.
No,
and it is not.
That is the privilege that
yes, they have evolved that.
Or the parliamentarians enjoy.
Yes, they have evolved that. They have evolved that theory. You have an absolute right, freedom of speech within the House. And if there is some, as lordships entertain, in the garb of that absolute freedom, Can anybody speak anything else? If somebody speaks something else, and it is not for the first time it has happened, if somebody speaks something, then Lord, the Speaker of the House may take an extreme stand. He may expel the member of the House. He may reprimand. He may, Lords, give any of the punishments which is well within the power of the Chairman of the Legislative Council or Speaker of the Legislative Assembly. My submission before your Lordships, therefore, Lords, is to take one step ahead. My first submission is it's a blanket protection given, number one. Once you enter the house, you saw it is some sort of sanctum, Lord, which gives you that complete protection. Number two would be, can you speak a slander? Can you speak something which is defamatory? According to me, Lord, even if there is something slanderous, which is defamatory in nature, which is an offense under the ordinary course of criminal law, it will be the House which has to take cognizance of the issue and not outside. But may I draw Lordship's attention to couple of, therefore, Lord, that Erkin's May's parliamentary practice, he says, criminal acts, howsoever, must be taken note of the House itself. May I request Lordship's Lords now to kindly see.
In your judgments is equity. Give that. Yes. In the copy model.
May I request Lords? Allah, sorry. Allah, you short preparation. If there is anything, Lords, I will request Lordships. I will give a matte kodtini.
Well,
sorry, ma'am. Idu first to Lordships may kindly see Sita Soren itself.
Siddharth. Give me all.
If I'll, I mean, Alinda format ಹೆಂಗಿರತ್ತಂತ I was not aware, so I was just giving it one by one minute, just so that the flow is also not.
Last moment on this is. But first, Lordships may kindly take Sita Soren itself.
Para 194.
Ali, first paragraph, their Lordships refer to 105 and 194. This would be page 666. So they describe what is the object of 194 subclause 2. Lordships would permit me to read first paragraph. Parliamentary or the fear or favor concept they have brought there. Parliamentary privilege codified in Article 105 and 194 of the Constitution is integral to deliberative democracy in facilitating the functioning of a parliamentary form of governance. It ensures that legislators in whom citizens repose their faith can express their views and opinions on the floor of the House without fear or favor. With the protection of parliamentary privilege, a legislator belonging to a political party with a minuscule vote share can fearlessly vote on any motion. A legislator from any remote region of the country can raise issues that impact her constituency without the fear of being harassed by legal prosecution. And the legislature can demand accountability without the apprehension of being accused of defamation. But this is the sentence I want. The whole of 105.2 is not once I go to Vidhana Saudha inside, Lord, I should not feel that for anything I speak today, I'll be drawn to by defamation. Police will be waiting outside to arrest me for defamation, or Lords, I will be called into a criminal court. I have been given that protection. And this is not very, very integral according to me. Of course, Lordships may not shorn of the facts. For instance, let us not, when Lordships are deciding this principle of law, Lords, as to this is merely an allegation, it has a different connotations. And I must bring to Lordships notice what the chairman actually took into consideration these allegations and is given a ruling. That will be in the second part of the submission. But in principle, I want to bring to Lordships notice that this kind of a protection, ordinary police cannot come and register a case against me saying you have outraged the modesty of 354. There is somebody.
Then who has to decide?
So that is the House. There is
even outraging the modesty of a woman would be decided by the House?
No. Only two circumstances. If my speech has resulted in outraging the modesty of a woman, only speech, That is whatever comes within 194 subclause 2. Okay, they have the power to grant punishment also. Lordships are aware, very famous
Yes,
cases.
yes,
But Lordships are aware. So only even if outraging the modesty of a woman, it results in outraging the modesty of a woman. But sometimes when Lordships are going to lay down the principle of law, if we are weighed down by these allegations, we may possibly, I mean, we can go wrong. But the point is not that. Today there is an allegation. That has been taken cognizance. Lordships may kindly take into account another angle. Let us say, today, I am one of the leaders of the opposition. I go get up and criticize the chief minister, criticizing him in a possible manner which may become defamatory in nature. But if the chief minister is to direct the police to register my case, my freedom or the protection given to me under 105(2) is taken away. A member of the ruling party may get up and say that the entire government is corrupt today. Lordships may, the government is correct, the chief minister is corrupt, the administration of the state is gone into the wrong. Let us say a speech is made. Now the chief minister, or a minister concerned for that matter, is justified in saying that you have called me corrupt without any justification. Will he go and lodge a defamation case? Will I be arrested? Obviously, if I have to come up with that plea, Lordships will say, no, you are protected by 105 subclause 2.
Yes.
But in fact, I may draw Lordship's attention and I'll try and retrieve that. Mr. H.N. Anjegowda, a very celebrated member of the Legislative Assembly, once, had criticized
this
former
requires
Chief
an
Justice.
answer and lot of issues. It can't be no drop of the hat way decided.
Yes.
Yes, SPPR.
Yes.
Complaint here ಮಾಡೋಣ.
ಮಾಡ್ಬೋದು.
Stay ಕೊಟ್ಟಿದೀವಲ್ಲ.
In the meanwhile, your Lordship's order has tied the hands of the magistrate.
Correct.
There was an application before the magistrate to furnish voice sample. Let that proceeding go on. We will not summon him. No, will not.
Once this court is seized of the matter,
Yes.
we will not permit any agency or any court to proceed further.
It is as good as staying the further proceedings.
Yes, exactly.
Your Lordship has said precipitate not to take any precipitate.
Now I will do it.
We have raised fundamental principle, fundamental question.
One minute, sir.
I'm sorry.
SPP, this needs an answer.
Needs an answer.
Whether this needs an answer. The answer should not get frustrated by your action of proceeding further. Nothing should become fait accompli. That's the reason.
We will not do anything. That the proceedings will, if the proceedings before the court is stayed, not investigation as far as investigation is concerned, we will not summon him for furnishing the voice sample or otherwise. There is an application before that will get delayed.
We'll decide. Now, why the mortal hurry?
Yes. Now,
not
this has been interpreted time and again. Now, what your Lordships will have to do is only to apply Sita Soren or other cases.
No,
there is nothing to be interpreted.
That is fine.
I'm sorry, my lord.
Courts have categorically said that the speech and the vote given should be with respect to the transactions in the parliament.
But nexus and
yes, and your Lordship has now expressed an opinion saying that it is either the House in session or not. No, it should be with respect to the necklace.
Now, when this man called derogatory remarks against the lady, the House was not in session?
It was not in session.
Why?
Even according
what was the time?
Adjourned.
What was the time?
Even the speaker in his finding, there is no finding as they claim. The speaker would said,
speaker was not in his seat.
No, speaker was not in the seat.
Please, sorry, but I'm sorry. Belliyappa represents the state. I'm sorry.
Problem, sir, 1 minute.
I have said in my complaint, the House was not in session. It was adjourned, and therefore the incident occurred. Now the speaker, there are complaints before the speaker. The speaker would not give an opinion, but would say that an unpleasant thing has happened, and this should not have happened. And he admits that it was when the House was not sitting. May I take a Lordship to that? Now, yes, those are admitted facts. Now your Lordship at the outset expressed an opinion saying that even if the House is not in session, that the privileges are there.
That's what judgment in Sita Soren would say.
No, it would not say so. Is my categorical submission. and six judge bench in Trivikram's case, Trilok Singh's case also has said it should have a nexus to the transaction of the business, what is said in the speech and what given thereafter. It is only confined to that. Even, my lord, in other six benches, there was a protest when the proceedings were going on. There were protests by the members. It is in the midst of a transaction. There was proceedings before the court. Then the tables were broken. That the criminal court took cognizance
There is a
of that.
difference
And the
between
court
breaking the
said
tables
that
and
such an
speaking.
incident.
Sorry.
I did not speak
I'm
when
sorry,
he was
sorry,
speaking.
sir, sorry.
This is
Problem, sir, wait. Yes.
the members.
I am also aware of that. It's not that.
Yes. It is a six-judge bench followed by Sita Soren, and the court held that such a protest, and if you break the mic, the stool, it amounts to a criminal offense. Therefore, it is not the immunity which grants under the 194 could be taken advantage of. There is no privilege. So therefore,
One minute. We'll notify the complainant.
We'll notify the
complainant, serve the complainant by way of hand summons. I'll take this on 6th, next week.
Yes.
We'll take this on 6th,
Yes.
or you want it on 13th.
13th may request, my lord.
One minute, we'll take it on 13th. Let objections also come about if you want to.
Yes.
I will pass an order, just listen to it.
Yes.
13.
I mean, Lord, and he refers to the procedures adopted by the Parliament. It is
As
House
can-
of Commons where there was a fight
as
between the
can
King
say-
and the House of Commons. Therefore, privileges were granted. What is more than granted in India? That does not apply.
Askins May's parliamentary privileges don't apply.
Yes.
The petitioner ಯಾರು ಮೇಡಮ್ ಅದು
ರಾಮ್ಲಾಲ್ ಅಲ್ಲಿ ಜಡ್ಜಸ್ ನ ಅರೆಸ್ಟ್ ಮಾಡಕ್ ಕರೀತಾರೆ ಅದನ್ನ ದಿಸ್ ಇಸ್ ದ ಕೇಸ್ ವೇರ್ ದಿಸ್ ಇಸ್ ಆಲ್ಸೋ ರೆಫರ್ಡ್.
the petitioner, a legislator in the council, in the legislative council, is said to have hurled derogatory abuses against the complainant. The complaint therefore becomes an offense punishable under section 75 and 79 of the BNS. Section 75 of the BNS is section 354 of the earlier regime, the IPC, and section 79, section 505 of the earlier regime, the IPC, both of which deal with a word or a gesture against a woman which would amount to outraging her modesty. This is the allegation against the petitioner as complained of by the second respondent complainant, another legislator. The hurling of those words or hurling of the speech or word or a gesture that has become the ingredient of the offense under section 75 and 79 of the BNS has admittedly happened inside the house. The learned senior counsel Prabhuling Nawadgi, taking this court through the book on parliamentary privileges by Askins May and the judgment in the case of Sita Soren, a 7-bench judgment in the case of Sita Soren, would seek to contend that any speech of any kind is completely immune under Article 194 of the subclause 2 of Article 194 of the Constitution of India. The learned SPP would, however, seek to refute the submission in contending that anything and everything done in the parliament or the legislature, as the case would be, would not have absolute immunity, but the cases, it would not have absolute immunity. He would submit that there are plethora of cases where the apex court has considered this issue and rendered that it is qualified immunity and not absolute immunity. The apex court in a judgment which arose out of vandalizing the furniture of a legislature in Kerala observes a judgment reported in state of Kerala versus Ajit, reported in 2021-17 SCC page 318, has observed as follows in paragraph 31 to 36. Quote that. The apex court holds, after referring to the privileges in the House of Commons of England and all the literature on parliamentary privileges, holds that the parliamentary privilege or the legislature's privilege of happenings inside the House is not absolute.
It is not followed.
Huh?
The House of Commons procedure, we have not adopted.
Is not absolute like it is in the House of Commons. The apex court has held that such privilege is qualified to crimes or ordinary crimes that are inside the house. The apex court in the said judgment holds that vandalizing furniture or criminal acts inside the house would not be covered under the immunity under subsection 2 of section 194 of the subclause 2 of article 194 of the Constitution of India. Therefore, the matter requires consideration. As the judgments galore from both the sides, both for and against their respective contentions, the complainant is yet to be notified. Therefore, the complainant, second respondent, be served by way of hand summons. A hand summons. List this matter on 13th.
Either on 6th or 20th, not on 13th.
6th ಆಗ್ಬೋದಾ?
20th may request 6th, 20th, subject to learned senior counsels.
List the matter on 20th ಇರ್ಲಾ?
ಅಲ್ಲ ನನಗೆ ಎನಿ ಟೈಮ್
20th may request.
ಅಲ್ಲ ಇದು come on online. You want to come here? And then pleasure is mine, no problem.
We'll all come online.
All right. So list on
6th.
6th, madam. My lord, 6th, my lord, there's a slight inconvenience for me. I would request
6th ಅವ್ರಿಗೆ ಆಗಲ್ಲ, 13th ನಿಮ್ಗೆ ಆಗಲ್ಲ.
20th ಇರ್ಲಿ, madam, subject to what learned senior counsel says, my lord.
Yes. So
20th.
Whatever, Lord. I wanted to come physically for this matter, Lordship. I want to come physically and address your Lord.
ಅವ್ರಿಗೆ ಪ್ರತಿ ವಾರ ನಾವು ಮ್ಯಾಂಡೇಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀವಿ ಇರ್ಲೇಬೇಕು ಇಲ್ಲಿ ಅಂತ.
ಅಲ್ಲ, I want to come physically, my Lord, and address.
ನೀವ್ಯಾಕೆ ಕೋರ್ಟಿಂದ ರಜಾ ಅಲ್ಲ, ಸಿದ್ಧಾರ್ಥ್ saying I can understand.
But I'm married. My child, I don't have anything, my lord.
February 14th is an important day. Siddharth saying is all right.
ಪಾಪ ಅಂತ ಇಲ್ಲ.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಇನ್ನೂ ಟೈಮ್ ಬಂದಿಲ್ಲ ಅದು ಹೇಳಕ್ಕೆ. Yes, we'll have it on 20th then.
Please.
Yes, list the matter on 20th in the fresh matters list. It is made clear the matter. ಅಲ್ಲ, ಅವ್ರಿನ್ನೂ ಬಂದಿಲ್ವಲ್ಲ. The complainant is not yet to come. The objections, list the matter on 20th in the fresh matters list. I'll mail heard in part of the ಬರ್ಕೊಳ್ಳಿ. Heard in part, the list the matter on 20th in the fresh matters list. The interim, in the light of the aforesaid issue to be decided, further proceedings in so and so shall remain stayed.
Please.
Yes.
Great.
You'll have to get over, sir, you'll have to get over Ajit's case, which is staring against you.
No, I'll straight away, Lord. That's what I wanted to. Lord, 194 subclause 3, Lord, differs from 194 subclause 2. I'll explain before your Lordship. Only one, not for academic purposes. Only for academic purposes.
Academic purposes, we have to decide this issue.
State of Kerala case ಅಲ್ಲಿ, Lord, 194.3, Lords, privileges keeps evolving. 194.2 freeze.
No. See, I'll tell you, sir, with my limited knowledge, of course, I'll tell you. One subclause 2 of article 194 speaks of frozen privileges.
Correct. That's what
where there is nexus with the transaction of business in the house, you are completely immune. But 194.3, as you said,
it is evolving.
No, it is not frozen. It is evolving.
Correct.
So it is a dynamic clause.
Correct.
Because of the dynamism involved in that clause, we will have to interpret it in a way where, yes, certain facts should become a crime, certain facts should be immune or otherwise. 194, we are not on that.
No, 194
194 2, transaction of business in the house is completely frozen immunity. Yes,
Correct.
anything you can speak, it will not be. 3, we will have to interpret, will do.
Correct. Absolute. That I agree.
Becomes academic.
194.3 is something not which requires to be interpreted. 194.2
This
is
needs
what
an
we are saying.
answer.
But anyway,
Yes,
I'll try and.
that
Well,
becomes
Prasad,
academic, yes.
is a very, very important issue and has wide ramifications.
Yes, Lord. Yes.
So it needs an answer. Will not decide it at the drop of the hat.
Yes.
We'll do it.
Certainly, sir. Certainly.
But I have had an occasion, lots in different contexts to look into this. Therefore, I thought I'll assist. Lord. In once, Lord, what happened just for Mr. Nanjagowda had spoken about the former Chief Justice of Karnataka High Court in a house. Then the question was, Lord, whether it amounts to then some ruling is there. Lord, I'll place it before the Lordship. That
Okay.
also.
Siddharth,
Please,
on
Lord.
the complete compilation Madi,
Please.
judgments, see how the state has done.
Please, I'll do that.
Same way you should do it.
I'll do that.
Yes. Now the
Please.
state is doing it perfect in all the cases. The research, paragraphs.
In Ramlal's case, the speaker would issue arrest warrant to judges who dealt with that matter.
Check.
1964 judgment.
Keshav Singh's case, not Ramlal's case.
51, Keshav Singh.
Keshav Singh's case, Ramlal alla.
51 Supreme Court.
ಅಲ್ಲ 64
yes.
ಕೇಶವ್ ಸಿಂಗ್ ಅದನ್ನೇ ಡೀಲ್ ಮಾಡುವಾಗ 64 ಅಲ್ಲಿ
64 ಅಲ್ಲಿ ಬರ್ದಿದ್ದು, but ಆಗಿದ್ದು Keshav Singh 1951.
Yes.
How about 51? First special reference number
Yes.
1 of.
No, first special reference ಅಲ್ಲ ಅದು. First special reference was Champakam Dorai Raja.
Yes.
Allala, he special reference 1 of 19.
That is 1951, AR 1951, page 26.
ನಮಗೆ 100 ಸಲ
That is first reference Champakam Dorai Raja. Yes.
ನಮಗೆ 100 ಸಲ ಓದ್ಬೇಕಾಗಿತ್ತು. ತಾವು ಅದು ಯಾಕೆ ಹೇಳ್ತಿರೋ ಗೊತ್ತಾಗಲ್ಲ ನನಗೆ. I've read 100 times, Lord. I cannot remember any of those dates or any citations.
Yes.
I'm grateful.
Yes.
Obliged.
We'll have it on 20th.
Yes.
Please, please.
ಮುಗಿಸ್ಕೊಂಡು ಅದಾಯ್ತಾ ಇದು? Then come back to Dharwad list.
Food matter. They are not taking matter for the recounting. But how the procedure
ಅವಿನಾಶ್ ಅಂಗಡಿ ಇಟ್ಟಿದ್ದಾರೆ. Let the AGA come.
in the application also they have sought for the recounting. On the application, without given any opportunity.
We'll see if there is procedural aberration, we'll consider, but I will not stop any process now. Yes, the petitioner is before this court seeking stalling of a recounting process to the elections conducted to what society? To Vivid Uddesh Prathamik Gramin Krishi Sahakari Sangh Niyamit. The sons. The learned counsel Prashant Kadadevar representing the petitioner would submit that the procedure has been given a go by while conduct of recounting. The learned counsel Avinash Angadi for the first respondent submits that all the procedure that is necessary in law have been followed. Notice was issued to the petitioner. Therefore, would seek dismissal of the petition. If the procedural aberration would ensue, therefore, the recounting shall not be stalled. The recounting shall be done, and the results of the election shall not be declared without the leave of the court, lest the matter on 6th Yes. ಏನು
Yes.
ಇಲ್ಲಿ ಕೇವೇಟ್ರು ಇದ್ದಾರೆ, ಇವರು ಇದ್ದಾರೆ. ನಾಟ್ ಈಗಲೇ ಫೋನ್ ಮಾಡಿ ಹೇಳಿ ಮಾಡಿ
Please.
ಅಷ್ಟೇ. ರೀಕೌಂಟಿಂಗ್ ಸ್ಟಾಪ್ ಮಾಡಲ್ಲ. ಪ್ರೊಸೀಜರ್ ಸರಿ ಇಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಸಿ ಲೇಟರ್. ಪ್ರೊಸೀಜರಲ್ಲಿ ಸರಿ ಇಲ್ಲ ಅಂದ್ರೆ ಲೇಟರ್ ಆನ್ ವಿಲ್ ಸಿ. So without the leave of the court, and the recounting process that is now held will be subject to the result of the petition. ಅಷ್ಟೇ. ಅದೇ ಹೇಳೈತೆ ಅದಾದ್ಮೇಲೆ. ಹೋಗೋಣ. ಮುಗಿಸ್ಕೊಂಡು ಆಯ್ತು, ಮುಗಿಸ್ಕೊಂಡು.
9, Sirajuddin Ahmed.
Madam.
Number 9, orders matter, Sirajuddin Ahmed.
Along with 439. List the matter on ಏನಿದು jail reforms da. We'll post it on 3rd March, 7th March. List the matter on 7th.
Number 10, Avinash V.
In terms of the memo withdrawn.
Number 11, Vaidya Ravi.
ಅಲ್ಲಿ ನಾವು
125 RP Act
313 ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಗಿದೆ.
ಇದಾಗಿ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ?
313 ಸ್ಟೇಟ್
ಅಂದ್ರೆ ಅಡ್ವಾನ್ಸ್ ಸ್ಟೇಜ್.
12 witnesses have been examined.
There is no Vidya Ravi or list the matter on 7th March.
13th, by that probably the trial.
March, not February.
Number 12, party in person, Srimati Leena Abraham.
Maintainability.
Humble submission, my lord.
Madam, you are here. What's the problem?
My lord, 19, the directions was given, my lord, for that entry maintenance application that set aside was given. And but even in the new order again, the maintenance was rejected on the reason that I am an educated woman and I have a responsibility of take care of the minor child, my lord. My respondent is earning 4 lakhs. I am right now a student, and the judge is very well aware of that. And I am even being a lot of disrespected also in the court, telling that you are only first year so and so. But how, being a student, I can go and work and even look after the child also, my lord. And
All
being
right. Will you serve your husband?
Yes, my lord. Last time during this.
No, now in this new proceeding, you serve your husband. I will take it up on 3rd March.
My lord, one more humble submission, because last time, my lord, you has told that the jurisdiction won't come under you to give. That is what it was being spoken to in the court. So, is it possible then to convert it with the writ petition, my lord?
All right, you file a memo to that effect. I will take it on 3rd March.
My lord, already I have filed this IA. In that, I am asking to convert it to the
One moment, madam. One moment. Emergent notice to the respondent, petitioner.
My lord, my matter or any other matter right now. It is in my matter only.
She wants to convert into writ petition.
Writ petition, my lord.
Criminal petition.
Yes, sir.
The Lord Council has filed an application seeking conversion of the subject petition to a writ petition. In the light of the application and the contents of the petition, the conversion so sought is permitted for the statistical purposes. So on. Yes.
Petitioner.
Deeply obliged.
Petitioner in person.
In person. Sorry, petitioner in person.
Obliged.
Yes.
Lord, petition, Lord, seeking transfer of the investigation to the CBI. Lord, the respondents number 7 and 8 are the elected representatives, Lord, in the Indi constituency, Lord, of the Legislative Assembly.
Post immediately after service of notice upon.
Lord, your Lordship would also kindly, Lord, consider, Lord, calling for the investigation records, at least some information. Lord, respondents number 7 and 10, Lord, are the accused persons against to. Yes.
Yaar, investigation reports against whom? From whom? State?
Yes, my lord. From Lord, respondents number 1 to 6.
Respondents 1 to 6 shall secure the investigation report and place it before the court on the next date.
And also the material.
We'll have it on
yes.
7th.
7th, my lord.
7th March, yes.
Grateful.
Here again, ये matter cell number 14. Bille aap.
I appear for the petitioner's counsel.
Yes, sir.
This may be called when sitting in Bangalore.
Sir. March 7th hakteni. List on 7th March. Heard the learned senior counsel, Professor Ravi Kumar, appearing for the petitioner. List the matter and additional SPP, B.N. Jagdish. List the matter on 7th March. Yes.
Number 15, admission matters. Vidya Shankarji Dalwai.
Ella entry matter irutte madam. Ella 7th March entry matter subsequent. Continue till the next date of here.
16,
heard
Patil.
so and so B.N. Jagdish eradu harput ಮಾಡಿ. 16 test Dalwai.
Yes.
Respondent part 2.
ಇದು entry matter ಇದೆಯಲ್ಲ ಅವತ್ತೇ ಬರಲಿ 7ಕ್ಕೆ.
I have to file amended. Charge sheet is filed after the interim order is granted. So I have to formally file an application for.
Madi. Learned counsel for the petitioner submits despite the grant of an interim
That
order.
has been clarified.
Last time ಹೇಳಿದ್ದೀರಾ clarify ಮಾಡಿ.
Affidavit is also filed and.
List on 7 heard the learned counsel Venkatesh Dalwai and B.N. Jagdish appearing for the state. List the matter on 7th March. Interim order subsisting will continue till the next date of court.
Number 17. Paula Chandra.
I am for the petitioner, my lord. My lordship already heard the matter, my lord.
7th March. List on 7th March. Interim order subsisting will continue till the next date of hearing.
Please, my lord.
Girish Kumar.
I am for the petitioner.
Yes, sir.
My lord is sitting in Bangalore tomorrow, my lord. I would like to be present before his lordship physically. If my lord is sitting in Bangalore tomorrow.
I will take it on 7th.
Please.
List on 7th.
Okay. Interim order may kindly be continued.
Interim order subsisting will continue to the next date of hearing. Yes, next.
Number 19. Sharad Jain.
Lords, 498A, my lords, where the marriage has not consummated is the allegation. Charge sheet is at page number 22, my lords.
Stay ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ.
Stay is not yet granted, my lords. If the stay is granted, my lords, notice can be issued to the respondent number 2. Both the
If stay is
constable.
granted, notice can be issued. Otherwise, illa anta.
Sorry, my lords.
Husband.
Husband, my lords, the only allegation is, my lords, stating that the marriage has not been consummated. Page number 22 is the charge sheet, my lords, where, lords. 4th line.
Brahma Kumari case.
My lord, I am for the respondent, complainant, my lord.
Yes, sir. ಅದಕ್ಕೆ 498 ಆಗತ್ತಾ?
Oh, no, my lord, kindly see the allegation, my lord, complaint, my lord. I don't have the petition, my lord.
ಅಲ್ಲ complaint ಬಿಡಿ, come to page 22.
My lord, I don't have the petition copy, the charge sheet copy, my lord, right now. My lord, any day next week, my lord, my lord, the allegation, my lord, with respect to the, my lord, the petitioner in, there's a mental and physical harassment also. My lord, and the complaint is filed only
Mental
against
harassment 498 ಬರಲ್ಲ, divorce ಮಾಡ್ಕೊಳ್ಳಿ.
Lord, physical
The
harassment.
only thing is that he has not let you come near him.
My lord, the other allegation is that, my lord, the petitioner here is police constable. My lord, and
Petitioner police constable.
Police constable, my lord.
Both are constables, my lords.
Even the
both are constables.
Both are constables.
But my lord, any day next week, my lord, I'll have a look at the charge sheet and I'll make submissions, my lord.
No doubt, charges like that. Yes. List the matter on. ಏನು ಟ್ರಯಲ್ ನಡೀತಾ ಇದೆಯಾ?
Lords, the date is there, my lords, on 13. Let them be stay, my lords. The matter can be decided. If you want to file objections, it's a matter of. Absolutely
Constable
like
versus constable, we'll see. Yes.
It's covered by your lordships that Ayappa Brahma Kumari case, my lords. Your lordships is clearly told.
Brahma Kumari case.
My lords,
yes.
I cannot say anything more than that, my lords, because.
Oh, ಆಯ್ತು ಸರಿ. Don't give that broad smile. Yes. Yes, list the matter on 13th. Next for 13th, Jagdish? 13th, yes. Copy Kodi, Abhishek.
My lords, my presence may be exempted on 13th, my lord, before the trial court. The matter is there, my lords. I'm also police constable.
The petitioner is exempted from appearance before the concerned court until further orders.
Obliged.
Bill number 20, Suyog.
For the petitioner, your lordship, sir. May seek for a short
Seventh,
Please agree.
heard the learned counsel of the petitioner, additional SPP, P.N. Jagdish. List the matter on 7th, interim order subsisting will continue to the next date of hearing.
21, N. Gautam Raghunath.
I am for the second respondent. I have filed affidavits.
Avata ಕೇಳ್ತೀನಿ.
7th lordship.
7th, madam.
Let them file an entire details before the trial court, my lord.
List the matter on 7th. Madam is objecting to that. Ali matte ತಲೆನೋವಾಗುತ್ತೆ. Yes.
Because they already filed an affidavit.
That's all
Before
right.
this Honorable High Court,
List the
so
matter on
my lord,
7th March,
this is the
interim
document.
order subsisting will continue till the next date of hearing.
Obliged, your lordship.
Heard the learned senior counsel, Srimati Lakshmi Iyengar, appearing for the petitioner and so on. Yes, next.
Bill number 22, Vachan GA.
Appearing for the petitioner, my lords.
7th. ಏನಿದು?
306, my lords.
Stay ಕೊಟ್ಟಿಲ್ವಾ?
No, my lords. 306 of IPC, my lords. The matter 3 times did not reach before your lordships, my lords. So there is no interim order.
Page 22. ಟೆರೆಸ್ ಮೇಲೆ ಏನೋ ಹೋಗಿ ಸಾಯಿ ಅಂತ ಹೇಳ್ದ ಅಂತ ಆಮೇಲೆ ಬಿದ್ರು.
Go and die ಮತ್ತೆ ಹೆಂಗಾಗತ್ತೆ?
No, my lords. They are only based upon the accused statement. They are filed this charge sheet, my lords.
What charge sheet?
Only relying upon the statement of the accused, my lords. No other material is there, my lords. The fact is that she had lost 51 lakhs, my lords.
That's all right. Go and die ಅಂತ ಹೇಳಿದೆ.
Page 22 ನಲ್ಲಿ
Column number 17, my lord.
ಅಷ್ಟೇ ಏನಾದ್ರೂ ಮಾಡಿಕೊಂಡು ಸಾಯಿ ಎಂದು ಹೇಳಿ
ಏನಾದ್ರೂ ಮಾಡ್ಕೊಂಡು ಸಾಯಿ.
ಆರೋಪ ಮಾಡಿದ ದುಷ್ಪ್ರೇರಣೆಯಿಂದ ಮನನೊಂದು.
The petitioner is before this court calling in question proceedings in CC so and so CC 3016 of 2024 registered for offense punishable under section 306 of the IPC. The allegation against the petitioner for it to become an ingredient of section 107 of the IPC is the words spoken, quote unquote, go and die or do whatever you want. This, in the considered view of the court, would not amount to abetment to suicide as obtaining under section 107 of the abetment to suicide as necessary under section 107 of the IPC. The permitting further proceedings would run foul of plethora of judgments of the apex court which considers the issue, all of which are considered by this court in criminal petition 4851 of 2024. ಅದು ಸಿಂಗಾರವೇಲನ್ ಅಂತ ಒಂದಿದೆ. ಸಿಂಗಾರವೇಲನ್ 4851 of 2024 disposed on 22/4/2024. Therefore, additional SP. ನಿಮ್ಮ ನೋಟಿಸ್ ಆಗಿದೆಯಲ್ಲ? ಆಗಿಲ್ಲ. The emergent notice to the complainant returnable by 14th of March. List on 14th of March. Next.
Obliged, my lords.
Next, PR.
Appear for petitioner, Swami. Appear for petitioner, sir.
Yes, sir.
Swami, OS you relative, Swami. OS pending ಇದೆ ಅರಸೀಕೆರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಅದಕ್ಕೆ
ಸ್ಟೇ ಇದೆ. ಅವ್ರು ಫಸ್ಟ್ 14 of 17 ಅಲ್ಲಿ ಸ್ಟೇ ಇದ್ರು ಕೂಡ ನಮ್ ಜಾಗಕ್ಕೆ ಬಂದು ಕಟ್ಕೊಂಡಿದ್ದಾರೆ ಅವರು.
ಅದಕ್ಕೆ
ಅಲ್ಲ ಅವ್ರು ನಾವು ಕೇಳಕ್ ಹೋಗಿದ್ಕೆ ನಮ್ಮೆಲ್ಲ SC/ST ಕಂಪ್ಲೇಂಟ್ ಅವ್ರು ಒಂದ್ CW6 ಸ್ವಾಮಿ ಇಂಟರ್ ಕೇಸ್ ಅಲ್ಲ ಸ್ವಾಮಿ. ಅವರು CW3 ಮೋಹನ್ ಕುಮಾರ್ ಅವರು CW6 ಹಸ್ಬೆಂಡ್ ಇದಾರಲ್ಲ, ರಿಲೇಟಿವ್ ಆಫ್ ದಿ ಒಂದು ಚಂದ್ರಪ್ಪ, ಅವ್ರು ಹೋಗ್ಬಿಟ್ಟು ಅದನ್ನ ಮಾಡ್ಬಿಟ್ಟು ಪೇಜ್ ನಂಬರ್ 73 ಸ್ವಾಮಿ.
ಅದು ಅಲಿಗೇಷನ್
ಅವರು ರಿಲೇಟಿವ್ ನ ಕರ್ಕೊಂಡ್ ಬಂದ್ಬಿಟ್ಟು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಬಿಟ್ಟು ನಮ್ಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರೆ OS ಸ್ಟೇ ಇದ್ರೆ 14 of 17 ಸ್ಟೇ ಇದೆ.
ಒಂದ್ ನಿಮಿಷ, 324 and 354 ಇದೆ
ಸ್ವಾಮಿ. ಅಲ್ಲ, ಇದು ಪ್ರೀ ಪ್ಲಾನ್ಡ್ ಸ್ವಾಮಿ ಪೊಲೀಸ್
Pre-planned?
ಪ್ರೀ ಪ್ಲಾನ್ಡ್ ಕರ್ಕೊಂಡ್ ಬಂದ್ಬಿಟ್ಟು ಕೋರ್ಟಿನ
Alright.
ಅವಾಗಿಂದ PDO ಮೇಲೆ ಕೂಡ ಇದ್ ಮಾಡಿದ ಸ್ವಾಮಿ. PDO ಕೂಡ ಇದ್
ಪರವಾಗಿಲ್ಲ.
ಮಾಡಿದ್ರು ಕೂಡ ನಮ್ದು 60 ಇರೋದನ್ನ ಈ
ಆಯ್ತು
45
ಈಗ
ಮಾಡಿ
ಕಂಪ್ಲೇಂಟ್ ಕೇಳೋಣ ವಾಟ್ ವಾಸ್ ದ ಪ್ಲಾನ್ ಅಂತ.
ಅಲ್ಲ ಸ್ವಾಮಿ ಕಂಪ್ಲೇಂಟ್ ಸರ್ವ್ ಆಗಿದೆ.
ಸರ್ವ್ ಆಗಿದೆಯಾ? ಬಂದಿಲ್ವಾ?
ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ.
ಬರ್ತಾರೆ ಬಿಡಿ.
ಬಂದಿದ್ದಾರೆ ಮಂಜೇಗೌಡ ಅಂತ.
ಮಂಜೇಗೌಡ ಅಂತ ಯಾರೋ ಇದಾರಲ್ಲ.
ಹೌದು ಸ್ವಾಮಿ. ಅಲ್ಲ ಅವ್ರು ನೋಡಿ ಸುಮ್ನೆ ಇದ್ ಮಾಡಿ ಮತ್ತೆ ಈಗ ಮೊನ್ನೆ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮೂವ್ ಮಾಡಿದ್ರು ಕೂಡ ಸ್ಟೇ ಕೊಟ್ರು. ಪೊಲೀಸ್ನವರು ಕೂಡ ನಮಗೆ ಸಪೋರ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ನಾವು ಮತ್ತೆ ಸ್ಟೇಟಸ್ ಕೋ ತಗೊಂಡಿದ್ದೀವಿ.
ಸಪೋರ್ಟ್ ಮಾಡ್ಬೇಕು.
ಅಲ್ಲ ಸ್ವಾಮಿ ಅಲ್ಲ ಸ್ಟೇ ವೈಲೇಟ್ ಮಾಡಿದಾರೆ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದೀವಿ ನಾವು. ಅದನ್ನ ಪೊಲೀಸ್ನವರು ರಿಲೈಸ್ ಮಾಡ್ತಿಲ್ಲ ನಮ್ಮ ಇದನ್ನ.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಎಲ್ಲಿದೆ?
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ ಸ್ವಾಮಿ ಅನೆಕ್ಸರಿ
ಸರ್ ಸಿವಿಲ್ ಸೂಟ್ ಅಲ್ಲಿ.
ಸಿವಿಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ನಾವು
ಸೆಪರೇಟ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಸರ್.
ಸಪರೇಟ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಆದ್ರೂ ಸ್ವಾಮಿ ಅವರು ನಮ್ಗೆ ಬೇಕು ತೊಂದರೆ ಕೊಡ್ಬೇಕು ಅಂತಾನೆ ಇವ್ರ ಕೈಲಿ SC ST ಕರ್ಕೊಂಡ್ ಬಂದ್ಬಿಟ್ಟು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರೆ ನಾವ್ ಏನ್ ಮಾಡೋದು ಸ್ವಾಮಿ? ನಮ್ ತಪ್ಪಿಲ್ದ ಇದ್ರು ಕೂಡ ಇದ್ ಮಾಡೋದಕ್ಕಾಗತ್ತ ಹೇಳಿ? ಕೈಂಡ್ಲಿ ಗ್ರಾಂಟ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಸ್ವಾಮಿ. ಅವ್ರು ಬರ್ಲಿ ಅಲ್ಲಿವರೆಗೂ ಇದ್ ಮಾಡಿ ಸ್ವಾಮಿ.
ಸರ್ pendency of a civil suit is no license for 354 or 324.
ಸ್ವಾಮಿ ನಾವು ಕೇಳಕ್ ಹೋಗಿ ಅದನ್ನೇ ಅವರು ಇದನ್ನ ಮಾಡ್ಕೊಂಡು ಅಡ್ವಾನ್ಸ್ ಇದು ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ನಮ್ಮ ಮೇಲೆ ಇದು ರಿಜೆಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
Counsel, one ನಿಮಿಷ. Heard the learned counsel for the petitioner. There is no representation behalf of the complainant. Awaiting his appearance, list the matter on.
ಸ್ವಾಮಿ until ಸ್ವಾಮಿ
one ನಿಮಿಷ sir. List the matter on 7th March. In the event the second respondent would not be represented, this court would
that is the intention ಸ್ವಾಮಿ ಅವ್ರದ್ದು.
This court would be constrained to grant an interim order of stay in favor of the petitioner. Yes, next.
Number 24, Dalwai Venkatesh.
ಇದೇನ್ ಸರ್? 500 ಏನಿದು? 153 ನಾ? 505
5 minutes. 353.
Page 13 and 14.
13 and 14.
ಇಂಟ್ರಿ ಮಾಡಲ್ಲ ಎಲ್ಲ ಬರ್ದಿದ್ದೇನೆ ಅನ್ಸುತ್ತೆ. ಇಲ್ಲೇ ಇದೆಯಲ್ಲ. ಬಿಲಾಲ್ ಅಹಮದ್, ಮಂಜರ್ ಸೈಯದ್.
But the allegation is that he has criticized the government for following my lord, supporting the people who speak about in favor of Pakistan and all. So therefore, my lord, they have invoked 505.
Clearly covered by even Javed Hajam.
Page 14 ಅಲ್ಲಿ.
Javed Hajam.
ಅಲ್ಲ page 14 ಅಲ್ಲಿ. Just above the second para.
ಅದು ನಾರ್ತ್ ಕರ್ನಾಟಕ ಭಾಷೆ ಇರುತ್ತೆ ಅದು.
Just above the second.
ಕಾಮನ್
ಆಚೆ ಹೋದ್ರೆ ನಿಮಗೆ
ಇಲ್ಲೇ ಸಿಗುತ್ತೆ.
ಇಲ್ಲ ಯಾವಾಗ್ಲಾದ್ರೂ ದಾಳಿ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ ಅದೇ ನಮಗೂ ಗೊತ್ತು. ನಾನು ಇಲ್ಲಿ 8 ವರ್ಷ ಓದಿದ್ದೀನಿ ಧಾರವಾಡದಲ್ಲಿ. ಎಸ್ ಕೊಡಿ ಜಾವೇದ್ ಹಜಾಮ್ ಕೊಡಿ. ಲೋಡ್ ಕಾಸ್ಟ್.
Number 25, Harish Ennath.
Lord, in this case, Lord, we have already filed, Lord, compromise petition and the joint affidavit, Lord.
Soft copy of compromise petition is sent to court.
Where are the parties?
ಪಾರ್ಟಿ ಒಬ್ರು ನಮ್ಮವ್ರು ಬಂದಿಲ್ಲ, ಅವ್ರ ಕಡೆಯವ್ರು ಬಂದಿದ್ದಾರೆ.
ನಿಮ್ಮವ್ರು ಯಾವಾಗ ಬರ್ತಾರೆ?
Anyway, Lord, a compromise petition along with joint affidavit is filed.
Offense
Consider ಸಮಸ್ಯೆ.
What's the offense?
Offense is 354, 504, 506, all those offenses.
All those 354.
Like a case and counter case, my lord. Petition number 14114.
ಎಲ್ಲಿದೆ compromise? ಎಲ್ಲಿದೆ sir? Where is the compromise?
Compromise, a soft copy of.
Yesterday, my lord, it was filed in the registry. It was filed in the registry.
Soft copy is sent to the court.
ಎಷ್ಟು 4 petition ಇದೆಯಾ? The petitioners.
ಒಟ್ಟು 4 ಇದೆ.
The petitioners in all these cases. The subject petitions are preferred. Calling in question so and so 4 prayer ನೋಡಿ. ಇದು
2 different criminal cases. 2 different CCs, my lord. CC number 59 and CC number 72.
Case and counter.
Case and counter case. The petitioners in all these cases call in question proceedings in so and so. The issue is a case and a counter case. The offenses against each other are the ones punishable under section 354B, 324, 504, 506 inter-alia. During the pendency of the subject petition, the parties to the list, both in the case and the counter case, have entered into a settlement and by drawing up certain terms of compromise. The terms of compromise as drawn by the petitioners and the respondents read as follows. In the light of the offences being the ones punishable as aforequoted and not being heinous or against the state, I deem it appropriate to accept the petition of accept the petition for compounding of the offences and close the proceedings against these petitioners for the aforesaid reasons. Proceedings in so and so criminal petitions disposed, so and so quashed. Yes.
Grateful note.
Petition notice ಆರ್ಡರ್ 356 of 25 ಅಲ್ಲಿ notice ಆರ್ಡರ್ ಮತ್ತೆ 114 notice
ಈಗ second respondent ಗೆ Lord, in both the cases,
ಅಲ್ಲಿ ತಗೊಳ್ಳಿ
please I'll take notice.
Learned counsel ಯಾರು ಹರೀಶ್ HR Harish NR is Harish NR accepts notice for the second respondent complaint 25.2, 25.3. ಅದನ್ನ ಬರೆದ್ಬಿಟ್ಟು ಆಮೇಲೆ separate.
25.3
case and counter case.
25.3 Sri
25.3 sorry SR Sri Prasad.
ಅದರಲ್ಲೇ ನಾನು please
ನಿವೇದಿತ ಮಾಡಿ 25.2 learned counsel Harish NR accepts notice for the second respondent complainant registry to print the name of so and so as appearing for the second respondent ಅಂತ separate order sheet ಮಾಡಿ. ಈ ಹರೀಶ್ NR ಅಲ್ಲಿ counsel SR Sri Prasad accepts notice for the second respondent complainant registry to print the name of so and so. ಆಮೇಲೆ compromise.
Complainant presence may be noted, madam. My party is present in VC.
ಆಯ್ತು ಸರಿ. Yes.
26 Chandrasekhar L.
This lords have directed us to serve the copy on the counsel representing the complainant before the trial court. In fact, the copy is served. Unfortunately, by oversight, the date is shown as 31st. It may be taken up tomorrow or any other date. ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ intimate ಮಾಡಕ್ಕೆ.
Intimate ಮಾಡ್ತೀರಾ? I'll take it on 6th.
Please,
List the matter on 6th.
Please.
Yes. Next.
27 Aditya Chandan Gowda.
This is a matter of that 294 has been invoked against me.
Multi-state cooperative.
No, my lords. This is at 294. Section 294 has been invoked.
Guru Kanwar Pal Singh.
Please, my lords. And also the fact that, please, my lords, the only problem is that the respondent number 2 has taken 3 dates for filing statement of objection.
Anyway, it has to be before me only.
Please, my lords, but there's some urgency. I made a mention that I have to travel abroad. So this is only coming. Kindly see page number 43.
Anyway, let's see. We'll take it next week.
Please, my lord.
Heard the learned counsel. First all yaro idara Chandrasekhar L. Still number 26 alva.
27. 27.
26 ಆಯ್ತಾ? Madam 26 ಆಯ್ತು. Oh, sorry. 27. Heard the learned counsel Aditya Chandan Gowda appearing for the petitioner, awaiting the appearance of the complainant. List the matter on.
My lords, the counsel has appeared for respondent number 2.
They have sought for time.
Where is he? Awaiting the appearance of the counsel for the respondent, R. Raja. List this matter on 6th. In the event the counsel would not be present, this court would be constrained to pass necessary orders. Interim order subsisting would continue till the next date of hearing.
Please, my lords.
Yes.
28 K. Ravishankar.
Petition. I am appearing for the petition.
Yes, sir.
Please. The interim order of granting maintenance under section 1425 is called in question.
Respond Parameshwarappa idara. List the matter on 7th March. Interim order subsisting will continue till the next date of hearing.
Yes. Number 29 Karyappa N.
I think there was
non-cognizable offense FIR
34.
13/4?
Daily orderly. The next date is shown as 30th/4.
30th April. Heard the learned senior counsel Hasmat Pasha appearing for the petitioner. This court on 6/11/2024 had passed the following order. The learned additional SPP B. N. Jagdish, who is present in person, submits that the next date of listing before the concerned court is 30th April.
ಇದರಲ್ಲಿ ಈ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಇಟ್ ಸೇಸ್ 34
Online 34, I think, sir.
ಡೈಲಿ ಆರ್ಡರ್ ಆ ತರ ಇದೆ.
That's a typing mistake. The learned additional SPP heard the learned additional SPP is also heard. List the matter on 7th March. In the interim order subsisting, the interim order aforequoted stands extended till the next date of hearing.
Number 30, Vijay Kumar Prakash.
I representing plaintiff, my lord.
Huh?
For 498A, reporting for settlement, my lord.
Yes, Yavat Pek.
March 1st week, my lord.
List on 7th March at the request of the counsel appearing for the petitioner. Next.
31st, 31, Naveen GS.
I represent the petitioner in this case. But offense under section 304A, Lord, I am the owner of the premises. My Lord, the incident, my Lord, happened wherein, my Lord, a child, my Lord, passed away because the gate fell on him accidentally.
What fell?
The gate, my Lord, the gate of the premises. It appears that he was playing on the gate. And, my Lord, the gate fell on him, my Lord, resulting, my Lord, in his death. My Lord, the only allegation, my Lord, there is no direct act, my Lord, as specified in Ambalal's case, my Lord, and my Lord, followed by your Lordship, my Lord, in Vishwas and another judgment. My Lord, in fact, my Lord, the eyewitnesses, my Lord, at pages 41, 43, and 45, my Lord, 3 eyewitnesses, my Lord, they say that I had given the repairing work to the second accused. My Lord, and I am a resident in Bangalore. So there is no direct proximity, my Lord, between the act.
Heard the learned counsel Satyanarayan appearing for the petitioner. The offense against the present petitioner is the one punishable under section 304A of the IPC. The petitioner is said to be the owner of the property. For an offense to become punishable under section 304A, twin acts are necessary to be present. One, acts which are rash and negligent. In the case at hand, neither of the two appear to be present for the reason that the child which was playing on the gate falls and dies of the incident. Though it is unfortunate that an incident has happened, the petitioner cannot be hauled into these proceedings. The issue in the list stands covered by judgment of the apex court in the case of Ambalal D. Bhatt versus State of Gujarat, 1972, 3 SCC, page 525. Therefore, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing. Yes.
Number 32, Srinivas.
Notice ಆಗಿದೆಯಾ ಸತ್ಯನಾರಾಯಣ್?
ಇಲ್ಲ, notice ಹೋಗ್ಬೇಕು ಸ್ವಾಮಿ. First time.
One additional SPP, 2 emergent notice returnable by 14th March.
Grateful.
Yes, next.
Number 32, Srinivas Rao.
My lords, I appear for the petitioner, my lords. I seek for an adjournment.
Adjournment?
Please.
13th. 13th.
What's the matter?
That Maniratna matter.
My lords, have engaged a senior counsel, my lords. Kindly have it anytime next week, my lords. Will address our arguments.
That's the matter? What's the matter?
Please,
Engaging senior counsel is the matter? You have not seen the file? Yes.
13th.
Where's the matter on 7th March?
13th. I think that somebody else.
My lords, interim order may be extended.
Urgency. 13th.
7th March. 7th March.
7th March. List the matter on 7th March. Interim order subsisting will continue till the next date of hearing. Yes.
33, Venkatesh Dalwai.
The ration cards were withdrawn by the government. In that context, my lords, the petitioner made a statement that selectively they are withdrawing to dissuade the votes. Not the 192, 196A and 353 is invoked. Not on per se, my lords, it is not applicable. Because
complainant yaru?
Complainant is the respondent. So motor complaint by the respondent.
Yes, sir. List the matter on 13th. Learned additional SPP B. N.
Notice
Jagdish is directed to accept notice. with
Stay ಇದೆ.
respon- huh?
Stay ಆಗಿದೆ ನೋಟಿಸ್ ಸ್ಟೇ
ಆಗಿದೆ.
stay.
ಅದನ್ನ ಮುಗಿಸ್ಬೋಣ.
ನಂದು ನೋಡಿ ಬೆಳಗ್ಗೆ ಒಂದು ಆಗಿದೆ.
ಮತ್ತೆ ಬರ್ಲಿ ಅಂತ.
ಒಂದು ಆಗ್ಬೋದು.
ಒಂದು ಆಗಿದೆ.
No, I'll give some more cases. ಇವ್ರದೇ ಕೆಲವೊಂದಿದೆ. ಸಾರಿ.
ಇನ್ನು ಮತ್ತೆ ಇದೆಯಾ? ಪೆಂಡಿಂಗ್. ಏನೀಗ ಸೈಲೆಂಟ್ ಆಗಿದೆಯಾ? ಎಸ್.
ದಳವಾಯಿ ಅವರು ಬರ್ಲಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ದಳವಾಯಿ ಅವರು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರ್ಲಿ.
I'll close this then. Yes, allowed. First, allowed first.
Number 34, Devarajayam.
I am but the petitioners, my lord. My lord.
Yes, sir.
My lord, I have been tagged into the case. My lord, they have been tagged into the case and the conspiracy.
Accused 4 and 5, sir.
Please, my lord.
Page 50, sir.
Please, my lord.
Yes, sir.
Page 51, my lord.
Yes, sir.
Page 51, my lord, second part. They have
Correct.
bifurcated, my lord, the offenses bifurcated.
ಹೌದು.
ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಇಲ್ಲಿಯವರೆಗೆ ನಡೆಸಿದ ತನಿಖೆಯಿಂದ A1, A2 ಆರೋಪಿಗಳು ಕಲಂ 61, 109, 329, 351 ಸಬ್ ಕ್ಲಾಸ್ 3, 352 3 ಸಬ್ ಕ್ಲಾಸ್ 4 BNS 23. A3 ಆರೋಪಿಯು ಕಲಂ so and ಮಲಟ್. ಲಾಸ್ಟ್ A4 and A5 ರಿಂದ A4 A8 ಆರೋಪಿಗಳು ಕಲಂ 61 BNS 23 ರೀತಿ ಅಪರಾಧಿಸು ತನಿಖಾ ಕಾಲದ ಸಂಗ್ರಹಿಸಿದ ಸಾಕ್ಷ್ಯಾಧಾರಗಳಿಂದ ಹಾಗೂ ಸಾಕ್ಷಿದಾರರಿರುವ ಹೇಳಿಕೆಗಳಿಂದ ಆರೋಪಿಗಳು ಕೃತವಿಸಿ ದೃಢಪಟ್ಟಿರುತ್ತೆ. I was not even present, my lord. Been tagged.
Plea of alibi, sir.
My lord, plea of alibi, my lord, those plea of alibi, my lord, at this stage I have not done that call, my lord. There is no meeting of minds. There is no agreement. My lord, merely because at one point of time, dates back to 2021, I was an agreement holder of the property in question. I have been tagged. But subsequently, my lord, that property came to be sold by accused number 6 to accused number 7 and 8. And now I cannot lay any claim also on the property, my lord. I have not consent to this proceedings, sir, between the intercept between the.
Serious, they've used.
No, offenses are serious. Devraj.
Please, my lord.
ಹಂಗಿದ್ರೆ ಅವಾಗಲೇ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
Discharge.
My lord, on that day, my lord, your lordship expressed, my lord, since expressed to grant other than A1 to 3, my lord, I'll grant for rest of the petitioners, your lordship expressed, my lord. And thereafter, my lord, at that juncture, my lord, they have submitted filed the final report. Therefore, my lord, I was advised to withdraw this, my lord.
Look into
I mean, other than this, my lord, there is no meeting of minds, not even iota of evidence to indicate that I have conspired with them at any point of time.
Wait, sir,
there is
wait,
no
sir.
reason for me to conspire with
sir.
them.
Yes,
Please.
list the matter in the fresh matters list on 6th.
But till then, my lord, it will be, my lord,
Till then ಏನಾಗುತ್ತೆ? ಏನಆಗಲ್ಲ ಒಂದು.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಮೊದಲು my lord, at first instance ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿರ್ಲಿಲ್ಲ FIR ಸ್ಟೇಜ್ ಅಲ್ಲಿ. ಈಗ ಮತ್ತೆ
on 6th we will grant, sir. Yes, don't worry. Yes.
ಅಲ್ಲ ಮತ್ತೆ ಕಮಿಟ್ ಆಗ್ಬಿಟ್ರೆ ಮತ್ತೆ ನಾನು ಮತ ಇದಾಗ್ಬಿಡುತ್ತೆ ಅದಕ್ಕೋಸ್ಕರ.
ಯಾರು ಕಮಿಟ್ ಆಗ್ಬೇಕು?
ಕಮಿಟ್ ಅಲ್ಲ ಬಿಟ್ರೆ
ಕಮಿಟ್ ಅಲ್ಲ. Yes.
ಕಮಿಟ್ ಅಲ್ಲ ಆಗ್ಬಿಡ್ತು ಅಂತ.
ಆಯ್ತು 6th ಏನಾಗಲ್ಲ ಬಿಡಿ, don't worry.
My lord, at least
don't worry. Yes. List on 6th in the fresh matters list. Yes.
Number 35, Mohammed Tahir.
ಏನ್ ಮಾಡಿದ್ರಿ?
Really, I placed those endorsement. In fact,
ಚಾಲೆಂಜ್ ಮಾಡಕ್ ಹೇಳಿದ್ರಲ್ಲ.
that's why I've given him a copy.
List the matter on 7th
appearing her petition, Lord.
7th March, sir. Yes, next.
Please.
Number 36.
My lord, I appeal for the second respondent in this case. This I have already submitted, my lord. Once again, I will be submitting. In 10,389 of 2023, my lord. The
Madhusudan Adigale, I have heard you. It's only for dictation. Yes.
My lords, in this matter, my lords, senior
just to
counsel
refresh
has
your
to
lordship, in the 10,389.
My lords, can I make a submission?
I'll post it.
I'll 1 minute. I'm submitting.
Release the matter from the status of dictating orders. List the matter on 7th March. Interim order, if any subsisting, will continue.
My lords, can it be on 13th, my lords? Senior counsel is present.
7th March, sir.
Yes, please, my lords.
So, my lord, it may be had at Bangalore, madam. My lord.
Bangalore, 7th March in Bangalore. Yes.
I saw.
37.
Idu tax. Vikram, sir.
My lord.
or R1. Vikram Huligol is no longer in the panel.
Oh, ನೀವಿದ್ದೀರಾ?
ನಾನಿದ್ದೀನಿ.
Registry to delete the name of Vikram Holigol appearing for the petitioner.
ಇಲ್ಲ,
Oh, sir, respondent, sorry. Respondent. Yeah, why is it before me?
dictating judgments.
ಯಾವಾಗ ಆಗಿದೆ ಇದು?
ಮೋಸ್ಟ್ಲಿ ತುಂಬಾ ಹಳೇದು.
ಹೌದಾ?
ಹಾ.
ದೀಕ್ಷಿತ್ ಸಾಹೇಬ್ ಮುಂದೆ ಇದ್ದಂಗಿದೆ ಎಲ್ಲ. V924 ನಮ್ಮ ಮುಂದೆ ಬಂದಿದ್ದಷ್ಟು.
ಹಾ.
2020. Wait, there is some order has to be passed on the administrative side. We'll do list the matter on 6th.
February.
Yeah, 6th, yes, 6th February. Karbadi.
Bill number 38, Prashant Nagendran.
My lords, for the petitioner, my lords.
Also appear for respondents in this case, my lords.
Yes, sir.
My lords, in this matter, my lords, this was a matter remanded from the Honorable Supreme Court.
Yes, sir.
My lords, there are 3 IAs pending consideration, my lords. One for amendment, one seeking for production of further documents, and a third for stay, my lords. My lords, there are subsequent developments, my lords.
Who appears for the complainants?
My lords, it has been served, my lords. Wakalat has been filed, which is showing on the High Court's website, my lords, as of 21st of January. Documents.
Yogesh Kumar.
No, my lords, it's another advocate's name is showing, my lords, in the website.
Then we'll do it. Supreme Court has fixed some timeline, is it?
They have not, my lords. There is no outer limit. But my lords, I'm not protected at this juncture, my lords.
We'll pass an order. The petition interim order is there already.
My
Lord,
lords,
there is an interim order, my lords.
There is
On the interim order, senior counsel was heard.
Yes, list the matter on 7th March.
My lords, if I may be granted the stay, my lords, it's only so far
There is
as
an
no
interim order,
coercive-
sir.
No, my lords, only no coercive action, no stay, my lords.
What is this, sir?
I pray, my lords,
It's here, sir.
that there's a stay on investigation, my lords.
The subject petition was allowed by an order dated 2nd August 2022 in 2022. The matter was challenged by the complainant before the apex court. The apex court remits the matter back to the hands of this court. Oh, this arrest matra. Back to the hands of this court to hear the other grounds as well and then pass necessary orders. Therefore, this court on 18/12/2024 had passed the following order. In terms of the said order, the bail that was in operation was observed that it also would be restored. In the light of the allowing of the earlier petition, in terms of the order dated 2nd August 2022 and the matter now being remitted and reheard, the further proceedings before the concerned court shall remain stayed. Investigation,
my lords.
1 minute. Investigation. If Supreme Court, if Apex Court has said it's a matter for investigation, I will not stay.
They have not commented, my lords. They leave it to my lord's discretion.
Lords, may I say this, my lords?
Am I audible, my lords?
Supreme Court says we may clarify that investigation will proceed subject to the orders which may be passed by the High Court.
Indeed, my lords.
No.
Therefore, my lords.
May not be stay better.
My lords, is this item 38, my lords? Am I audible, my lords?
Yes, list the matter on 7th March.
Lords, stay, my lords, if may be
No,
granted to.
Supreme Court says matter for investigation. Where will I
My lords,
stay?
says it leaves it to my lords' discretion, my
No, no,
lords. There are developments, my lords, documents
Milords
which
may
suggest.
be permitted to submit, Milords.
Yes.
Milords, in fact, on this interim order, arguments were heard, Milords. This court after that had told, let them not take coercive action, let the investigation go on, Milords.
That will
Because if they
yes.
want modification, Milords, they may have to argue on that.
List this matter on 7th March. Orders subsisting, the protective orders subsisting against the petitioners shall continue till the next date of hearing.
My lords, it was clarified that my bail is valid on the last date, my lords.
That
Not
is there, sir.
merely protective orders, my lords. If I may be permitted to
Okay,
grant.
don't obfuscate the issue. Wait. Yes. Next, again, but protective orders. List on 7th.
Deeply obliged, my lords.
Arnav Bagalwadi.
My lord, I appear for the petitioner in this matter, my lord.
Interim order then.
There's an interim order subsisting, my
Yes, 7th March. Interim order will continue
lord.
next.
For 13th March, my lord, we'll be
7th
present.
March, madam. Yes.
Bill number 40.
That's number 40.
Milords, this is a matter pertaining to.
Kumar sir.
Lordships.
Nim submission ge wait ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
Sorry, my lords, I 2 occasions. One again I missed the hearing because I was held up in the court. Other one day, my mother was hospital. I could not appear.
No problem. I will hear you on 7th.
7th, my lords.
7th March.
7th March. Obliged.
List the matter on 7th March. Interim order subsisting will continue to the next date of hearing.
As far as first petition, there is no interim order. Only in second petition.
Wherever it is.
Obliged. Obliged.
In Gunashila's matter, there is an interim order, my lords.
Wherever sir.
Criminal petition.
Where he had resigned from the company and then
will continue till the next date of hearing.
40.1, I may be permitted to file the synopsis, Lord, that Dharwad.
Please file sir, in anything. Yes.
Bill number 41. Aniel Joseph.
I appear for the respondent, my lord. Connected matter is not connected, my lord.
Summons.
Lord, connected matter, your lordship, on the last occasion, my lord.
Connection, which connected matter?
That is WP number, my lord, 9468 of 2022. Your lordship, may kindly see lordship's order dated 23rd January, my lord.
Tag this petition along with writ petition 9648 of 2022.
It's already an order, my lord.
It's already, this court on 23/1/2025 had passed the following order. Therefore, the registry is directed to tag the petition as directed and list them all on 7th March 2024 for further hearing.
Grateful, sir.
25.
42. Vijeta Arnav.
I appear for the petitioners, my lords.
Idu ashte same day. Interim order subsisting will continue to the next date of hearing.
43. Sir. Samir S.
For the respondent, 43.
Yes, sir.
They were the petitioners are undertaken to refund the sale consideration. Also, as per the agreement of sale,
refund agilva?
Illa, madilla.
We'll see. 7th March, heard the learned council and BN Jagdish, additional SPP here. List the matter on 7th March. Interim order subsisting will continue to the next date of hearing. Next.
Number 44.
44, I am appearing for the petitions council, my lords. Batch of
the respondents in this case, please.
I'm seeing the senior counsel after a long time. I thought you forgotten this court. Yes.
Not at all, my lords.
Yes, sir.
Lords,
the
charge sheet has been filed. This case is, my lord, that subsequent to
Lords, it's
ಏನ್ ಕೇಸಸ್ ಇದೆಲ್ಲ?
Lords, it is something like this, Lords. Lords, the petitioner purchases a property under registered sale, which is an apartment from one Veena Narayan on 22/11/2019. Lords, on one of the occasions, Lords, in the year 2021, to be precise, on 13/8/2021, Lords, goons enter into his house. Lords, they forcibly make me sign on a document called as an agreement of sale in the name of a fictitious person and one book of check leaves with the checks.
Oh, this is
yes,
We had got the officer, Ada.
Yes, no, not this, my lords.
All right.
Lords,
Yes.
this complaint is registered, my lords, before the police. It mentions the check numbers. Lords, then the problem starts for me. All the people who are connected with this Veena Narayan files complaint one after the other. The first of the complaint is by saying that I wanted to facilitate fixing up of the closing of a GST claim through a GST officer. In that, he makes a reference to the checks which is subject matter of my complaint, saying that these are the checks which are given. This is challenged on the ground of improbability because there is no claim pending before the GST Commission. He is already before the court saying that my claim is not pending before the GST court, therefore direction should be issued to consider it. Second of the complaint, my lords, is filed by Veena Narayan herself saying that for interiors there was a separate consideration payable which is not being paid, therefore there is section 420. Note the third complaint is filed by a person who was a witness to the instrument who says that my signature was obtained fraudulently on the guarantee documents for which the loan was borrowed for the very same property. There is no default of the loan. This is the third complaint. All these three are now subject matter of consideration at your lordship's hands.
Two options replace the dictating and hakirla.
Clubbing of all these things, and I've been told, my lord, charge sheet has been filed. But
it
5026.
May I submit only one thing, please?
1 minute, Rajat,
Yes,
Ravi Shankar
please.
sir and Rajat.
Please, Milords.
If there are two options. I have not treated this as parted. I may release it and post it before the regular bench, or I'll have it on 7th.
Lordships may have this matter on 7th.
7th March.
Very well.
I'll be
So
there.
my only
Bangalore
submission
will
is
have-
this.
we'll
No,
have
my
it
only
on
submission
7th.
is this is at the
Yes.
FIR stage, and my lords have granted an interim order in favor of an accused who is
Charge sheet
commonly accused.
ಹಾಕಿದ್ದಾರೆ ಅಂತ ನೀವು
ಇಲ್ಲ,
records
my lords, that's what I want to submit.
In fact, my
The-
lord, 44.5.
heard
No, the only
Leonard's-
submission is this, my lords. This is the accused who is alleged to have forged the chief minister and the governor's letterheads. This
I
is
know,
the accused.
we'll
No,
consider
I
that.
don't think that is
If-
subject matter of any of the complaints.
In those cases, my lord, where the FIR was registered, charge sheet has come to be filed, and that case, my lords, has been withdrawn. That, my lord, has no bearing on the cases connected in the first four matters.
Heard the learned senior counsel D.R. Ravi Shankar for the petitioner along with Vinayak so-and-so appearing for the petitioner and the respondent, additional SPP for the state and Rajat for the complainant. At the list the matter on March the 7th, 2025. To hear them further. Interim order subsisting will continue.
44.5, my lord.
Withdrawn, 44.5 withdraw ಅಲ್ಲ?
Yes.
ಮತ್ತೆ ಬಂದಿದೆ ಅಲ್ಲ ಈಗ 44.5 withdraw ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Learned counsel submits that he would wish to withdraw the petition 5 criminal subject petition in the light of the said submission disposed as withdrawn.
Please, minutes.
ಅದಕ್ಕೂ ಇದಕ್ಕೆ ಏನ್ ಸರ್ ಸಂಬಂಧ?
Lords, may I request, my lords, the investigation papers to be called for, my lords, in this case. It was previously called for. Please.
Learned additional SPP to secure and place the investigation papers on record on the next date of hearing.
Lordships.
Deeply obliged.
45, Gangadhara DC.
My lord, I appear for the respondent. This could come, my lord, on 7th of March.
I appear for petitioners, my lord.
PCR, my lord, complaint under 200 for an offense under 500 of the Indian Penal Code. Sworn statement is recorded by way of affidavit. And my lord, he is my neighbor. And the allegation against me, my lord, in relation to a complaint which I had filed at the police station. The crime beat of that newspaper, my lord, has publicized, my lord, that a FIR has been registered. His allegation, my lord, against me is I have got the news article published, my lord, in the newspaper. Without public, my lord, the merits that are involved, my lord, and the facts that are pleaded in the complaint. And just, my lord, request my lord to kindly turn to the order sheet, my lord, to get a page number 46.
ಇದೆಯಲ್ಲ 7ನೇ ತಾರೀಕು ತಗೊಂತೀನಿ ಅಲ್ಲೇ ಬರ್. Heard the,
Leave it upon, my lord, this entire complaint should go.
we'll see. I've protected you now. Any problem? Any problem?
No,
He's saying some problem. Yes. No problem.
no problem.
Because he is my neighbor. And
Lord, they have filed a false
Settlement. False atrocity case.
Please, my lords. After they contest the B report, B report is also rejected. They go around the community accusing me of making casteist remarks.
So no settlement.
Lord, I reached out to them. They are not willing to say.
Your neighbors and you don't want to settle?
Lord, I reached out to them, in fact, after the last date of hearing.
Manu, 1 nimsha. Yes.
My lord, I put it to my lord, the petition. That, my lord, this is the litigation ought not to be continued. And my lord, I advise them that the matter ought to be settled. Ultimately, my lord, she is my neighbor. We share a common compound. And my lord, the petitioners are amenable for any settlement. In fact, my lord, my instructions are at a point of time when an OS that was filed by the respondent, I would go and approach the respondent saying that why are you doing all this? Come, let us settle the matter. Ultimately, you have also purchased the property next to me. I have purchased the property next to you. It is not a child's game that because of this dispute, I would sell my property, neither you would sell your property. Let us live in harmony. But what the respondent would say is, let me take this litigation. Let us see what this litigation will end up with. Yes. My instructions are the petitioner, my lords, are absolutely, my lords, willing to have a settlement talk with the respondent, are absolutely not willing to, my lords, continue the litigation that are pending inter se between the parties.
Yes, Manu.
Lord, I reached out to them. In fact, Lord, since one of the parties is an advocate, I spoke. The point where the discussions.
One of the parties an advocate?
Please, my lords. The respondent.
Complainant is an advocate, is it?
Sorry,
my lord. Complainant is an advocate.
Yes. The petitioner is an advocate. The accused is an advocate.
A complainant, my lords, in the police complaint. The complainant who is the respondent before your lordships is not the advocate.
Complainant in the false.
The petitioners before your lordships are advocates.
All are advocates.
Our Tande, our Maga Mate, daughter-in-law, both of them are advocates.
Okay.
I spoke to them in person because they came on the phone. The only demand that my client made was, please say sorry for the complaint under the Atrocities Act. Rest of the disputes we will settle. They said no. Then, my lords, it leaves a hanging sword on my head. Tomorrow morning, they will file another complaint. Where will I go?
Sorry is not possible.
No, my lords. If my learned friend, my lords, has completed, I shall assist your lordships.
No, he is at sorry, Ashte. He is not completed.
What they put it, my lords, to the respondent is, you also apologize for what you have done against us at this point of time. We will also apologize.
Yes,
we are both neighbors.
This wasn't told to me. If this is asked,
let bygones be bygones. You just sit across and strike out what is this dispute between the neighbors and
yes,
so much of litigation.
My lords, I am ready. In fact, I did not know that my learned friend is appearing. I will speak to him. I will make, my lords, every endeavor to settle the matter.
Got highest regards, my lords, my learned friend, Mr. Manu Kulkarni.
Yes. The list the matter. I'll take it on 13th.
Very well.
Or 7th. Give you some time.
7th.
Yes, list the matter on March the 7th, 2025. In the light of the issue arising between neighbors, I deem it appropriate to direct the parties to the list to sit across and explore the possibilities of arriving at an amicable settlement so that all the litigation between the two could be given a quietus. In the light of could be given a quietus. Interim order, if any subsisting, would continue till the next date of hearing. List the matter on 7th March.
In fact, my lord, since I have the advantage, my lords, of the audience of this court, I must bring it to your lordship's notice. My lord, this is a villa where, my lords, the infrastructure of all the villas are the same. What, my lords, the respondent would do is, in between, my lords, the fabrication structure that is there between my house and his house, my lords, he covers the entire, my lords, fabrication with a polycarbonate sheet. And, my lords, he has completely ostracized me in the entire community. My children, my lords, are not allowed to play with the rest of the children in the community.
With utmost respect.
Please.
My lord, with utmost respect.
My children are not allowed to play with the rest of the children in the community. I am not invited, my lords, to any of the functions of the association.
My lord, with utmost respect.
My lord, that is the high-handedness, my lords, of the respondent. He is, my lords, a member of the association. In fact, my lords, he has gone to the extent of saying that the complaint that I had filed is false. My lords, there is no finding that the complaint that I had filed is false, except for the fact that the B report has been accepted, and that the B report, my lords, is not on a finding that the allegation that I have made out against him is false. It is on the fact that, my lord, there was no evidence only.
All right. We'll see.
Very well.
Settlement
Very
doesn't come about.
Very well. In fact, my lords, I have advised the petitioner.
I'll answer it on merits.
No, in fact, I have advised the petitioners, my lords, that this litigation ought to be closed by way of a
We'll see.
settlement.
If it doesn't, then we'll answer it.
Very well, very well.
Not with
I'm so very
utmost
great.
respect, if I may just say one sentence, most of what is being said is not at all relevant here. The only relevant issue, my lords,
I'm not asking whether it is relevant, but it is correct.
it is fully false, absolutely false.
May I just produce, my lords, this memo? In fact, I asked him, my lords, to give me all the photographs, my lords. I shall place those photographs. I can serve it, my lords, on the council for the...
Settlement agrilla andre then come across. We'll
Very
see.
well.
We'll answer it on merits. Yes.
My lords, may direct the extension of the interim order.
That will-
But I'm so very
Order
great.
subsisting will continue. Yes.
Bill number 46, Abhishek K.
46, my lord, next week.
Oh, no, sir.
May make one submission. Yesterday, I prepared objections or some corrections that needed. Department wanted some correction. I'll file my objection in your lordship meeting.
He has aired a television program on Muda scam and you registered. a
I
claim
believe,
against him.
and that is exactly, my lord. Next week, my lord, I'll file. My objection was sent to, there are some corrections they want.
Yes.
Next
7 days, my lords, the last 7 days.
List the matter on 6th March at the request of the
February.
additional SPP. Yes, interim order subsisting will continue till the 6th February. Yes. Interim order subsisting will continue to the next date of hearing. Yes.
47, Sridevi Bhosle.
7th March.
The petitioner will also.
7th will come there and decide, madam. Yes.
Please, my lords.
48, Nagendra Dixit.
Interim order, country order.
Lord, appearing for the respond number 2, my lord, the original complainant.
Lordship.
This honorable court has already granted the interim order. Therefore, I am requesting they kindly have this matter on 7th, my lord.
7th March. List the matter on 7th March. Interim order subsisting will continue to the next date of hearing.
Kind submission, Lordship. Kind submission, Lordship.
There's ready, sir. 7th. Yes.
Bill number 49, Veeraya Hiraman.
Wildlife protection covered. Final report despite 7 years. 7th March interim order next.
Bill number 50, Jeevan Kumar.
Plus, I appear for the petitioner.
Bowie.
ಗೋವಿ ಮೆಲೋಡ್ಸ್ 26/9 ತಾವು ಆರ್ಡರ್ ಮಾಡಿರೋದು ಇವತ್ತಿನವರೆಗೂ ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಹಾಕಿಲ್ಲ.
ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಸ್ಟೇ ಆಗಿದೆ ಇಲ್ವಲ್ಲ?
ಇಲ್ಲ, ನೀವು 26/9 ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ವಾಸ್ ಪರ್ಮಿಟೆಡ್ ಟು ಕಂಟಿನ್ಯೂ. But till today, Milords, even after 5 months.
List on 7th March, the learned additional SPP.
And one more, Milords, one more submission may I make?
The investigation papers and place it before the court on the next date. Yes.
Milords, with regard to investigation papers, our money flow chart and the copy of the investigation report anತಾರೆ. The old IO has produced it in our bail application.
Interim order subsisting will continue till the next date of hearing. ಏನ್ ಮಾಡಿದ್ರಿ
ಅವ್ರ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪೇಪರ್ಸ್ ನೆಲ್ಲ ಅವ್ರ ಬೇಲ್ ಅಪ್ಲಿಕೇಶನ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ.
ಕೊಡಿ 50
ಮೆಲೋಡ್ಸ್.
ಇದಕ್ಕೆ ಮತ್ತೆ ಅದನ್ನೇ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
51 ಅಲ್ಲಿ ನಾವು 17A approval.
ಇನ್ನು
ಕೊಡ್ತೀನಿ ಅಂತ.
No, my lord, in this matter, my lord, the lordship lastly heard, my lord, this is the prison matter. And last 3 months, they have not placed any piece of paper, my lord, before your lordship.
ಗೊತ್ತಾಯ್ತು. ಜೈಲಲ್ಲಿ ಸ್ಟವ್ ಚಪಾತಿ ಮನೆ.
ಹೌದು, ಇದನ್ನ ಇದು ಮಾಡಿದಾರೆ. ಅದಕ್ಕೆ ನಮ್ಮಲ್ಲಿ ಏನು ಅಲ್ಲ, your lordship
matter on 7th March. Yes, next.
ಅಲ್ಲ, some early date, my lord, in this matter. Your lordship may for a moment take a single page, my lord, in page number 12.
Sir, ಜೈಲಲ್ಲಿ ಆಗಿರೋದು ಗೊತ್ತು ಸರ್. ಎಸ್.
Yes, my lord, they are in suspension, my lord, due to this case, my lord. They are under suspension.
ಜೈಲಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂತ ಗೊತ್ತು.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಏನಾದ್ರು ಒಂದು ಪೀಸ್ ಆಫ್ ಪೇಪರ್ they have produced, I will
ಯಾವ
agree.
ಪೀಸ್ ಆಫ್ ಪೇಪರ್ ನೀವು ಚಪಾತಿ ಮನೆ ಅದೆಲ್ಲ ಮಾಡ್ತೀರಾ ಅಲ್ಲಿ ಇಲ್ವಲ್ಲ?
ಚಪಾತಿ ಮನೆನ ಅಲ್ಲಿ ಒಳಗಡೆ ಇದ್ದಿದ್ನ ಅವ್ರು ಇಟ್ಕೊಂಡಿದ್ನ, ನಾನು ಬರೀ ಸೂಪರ್ವೈಸರ್
ಇರೋದೆಲ್ಲ ಬಿಸಾಕ್ಬಿಟ್ಟು ಬರೀ ಚಪಾತಿ ಮನೆ ಇಟ್ರೆ ಅಲ್ಲಿ
ಒಳಗೆ ಇದೆ ಸ್ವಾಮಿ.
ಆಯ್ತು, piece of paper will see. Yes.
Otherwise, your
ಏನ್ ಸ್ಟೇ ಕೊಟ್ರೆ ಸಸ್ಪೆನ್ಷನ್ ರಿವೋಕ್ ಆಗತ್ತಾ? Yes.
consider matter on merits itself, my lord.
On merits itself, I will let the additional SPP get the records. Yes.
Last 3 months, they have not.
Additional SPP is directed to secure the records of investigation and place it before the court. List the matter on 7th March.
Some early date, my lord.
7th March, sir. Next.
52 Praveen.
Some early date, my lord.
Next. Yes. Praveen.
My lord, I appear for the petitioners in this case, my lord. Two things, my lord. Despite their stay being granted by the
ಯಾಕೆ defreeze ಮಾಡಿಲ್ಲ account? There is an order earlier to defreeze the account. This investigating officer is behaving.
My lord, I may make a submission, please. Investigating officer should be called to the open court and admonishment.
ಅದು ನೋಡೋಣ ಒಂದು ನಿಮಿಷ. This court on 1 minute, Praveen. This court on 19/9/2024 had passed the following order. Again on 26/11/2024 had passed the following order. The learned counsel Praveen C representing the petitioner again on 12/12 the following order. Till today there is no answer as to why the petitioner's account despite the direction is not defreezed. Therefore the investigating officer shall be present before the court on 13th February at 2:30 p.m. Yes. Next.
Bill number 53, Ajay Jain.
My lord, I appear for the
Yes. Let it go before the regular bench.
For the respondent.
Release the matter from the status of being part heard. List the matter before the bench having appropriate roster. Next.
Bill number 54, Dinesh Kumar Rao.
I appear for the respondent number 2, my lords.
Six, serial number Udayawalla, sir. Heard senior counsel Udayawalla appearing for the petitioner and counsel C.H. Jadhav representing the respondent. Yes, next.
I'm for petition, my lord. Kindly take this matter on 6th, my lord.
My lords, humble
Physically,
submission.
he want to
was
appear.
The charge sheet has been filed in the matter, my lords.
Yavrali, sir?
54.
Serial number 54, my lords.
Challenge ಮಾಡ್ಬಿಡಿ.
On kindly have it on 6th, my lord.
ಅದು ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿದ ಚಾಲೆಂಜ್ ಮಾಡಿ. ಬೇಡವಾ?
6th it will. Physically, you want to
list the matter on 6th at the request of the counsel appearing for the petitioner. Next.
55, Sadhana is this.
I appear for the petitioner, my lords. My lords, is the same case which my lords famously calls as 4 goats case, my lords. My lords are
correct. Respondent is not appearing at all.
My lords, on the last occasion, my lords observed that if the counsel does not appear today, then the matter would be heard in his absence. My lords, the offense of 306, my lords. My only contention, my lords, is that there is no proximity between the action of the petitioner and, my lords, the death of the, my lords, the deceased. Here, my lords, one fact which I have to press, my lords, is that page number 23 is the charge sheet. My lords, on 10/8/23, my lords, the deceased commits a suicide. But the reason quoted is that on 7/8/2023, that is 3 days prior, my lords, that I have gone to his house and I have taken away 4 goats of his. That is the reason quoted, my lords. So my contention is, my lords, that there is no proximity between the action and the...
Yes, Jagdish. 4 goats. Yes, heard the learned counsel, Srimati Sadhana Desai appearing for the petitioner and
My lords, one more submission.
additional SP. Yes, madam.
My lords, may I please rely on this case? I'm very sorry, I'm unable to place it.
That's all right. Citation.
This is 2024 INSC 960, Apex Court Judgment, my lords.
Party name?
The parties is Jaideep Singh, Praveen Singh Chavda versus State of Gujarat. Para 23 becomes relevant, my lords. May I please read, my lords? It's just 4 lines.
Yes, madam.
The act of abetment must be explicitly demonstrated through actions or behaviors of the accused that directly contributed to the victim's decision to take their own life. Harassment in itself does not suffice unless it is accompanied by deliberate acts of incitement or facilitation. Furthermore, these actions must be proximate to the time of the suicide, showcasing a clear connection between the accused behavior and the tragic outcome. It is only through the establishment of this direct link that a conviction under Section 306 IPC can be justified.
All right, order reserved. Yes.
Grateful, my lords.
Next.
56, 10 under BS.
My lord, I am for the petitioner in this matter. The last date, my lord, your lordships had directed the state, my lord, to file affidavit of the doctor. This is advocates.
Yes. Adhe, 12 hours ali, no injury, full body injury.
Full body injury. And now, my lord, I have secured further papers from the government of. They have crossed everything, my lord. ಎಲ್ಲ ತಿದ್ದುಪಡಿ ಮಾಡಿಬಿಟ್ಟು ಎಲ್ಲ ತಿರ್ಗಾ ಅದನ್ನ ರೆಡಿ ಮಾಡಿದ್ದಾರೆ ಸೆಕೆಂಡ್ ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್
ಎಲ್ಲಿ
my lords may
one nimsha, I had asked the doctor to file some affidavit.
Yes on the last date your lordships had asked.
Yes sir, yes.
We have not
informed. We will issue bailable warrant to the doctor.
We have not informed our office.
Sir, this order is on 9/12. ಇದು ಪೇಪರ್ಲೆಲ್ಲ ಬಂತು ಅಂದ್ಬಿಟ್ಟು ತಿದ್ಬಿಟ್ಟಿದಾರೆಲ್ಲ. If I get to know, I will initiate direct prosecution to be initiated against the doctor. ಇವತ್ತು ಸಾಯಂಕಾಲ ಬಾಡಿಲಿ ಏನ್ ಇಂಜುರಿ ಇಲ್ಲ, ನಾಳೆ ಬೆಳಗ್ಗೆ 6 ಗಂಟೆಗೆ ಬಾಡಿ ಫುಲ್ ಇಂಜುರಿ. Yes. This court on 9/12/2024 had passed the following order. There was a clear direction to the doctor to file his affidavit on the contents of the order. The learned additional SPP submits that he needs another 6 days time to get the affidavit filed. In the event the doctor would not come up with his affidavit on the next date, the coercive arm of law would be unleashed against the doctor. List the matter on 6th February. Interim order subsisting would continue till the next.
So that is further orders are this. It is still it is granted till further orders.
List the matter on 6th for further hearing.
Please, much.
Number 57, Vivek Holla.
So I am for the petitioner. This may be taken up on 7th March.
7th, yes.
Please. Great.
List on 7th.
State, case Mallikarjuna.
Lordship, in this case, I am appearing for the petitioner, my lordship.
Same day.
I am already filed synopsis and citations
List
and
on-
also detailed objections, my lordship.
List on 7th March. Yes.
59, A. Mahesh Chaudhary.
That's I appear for the petitioner in this matter.
That's for respondents.
That's this matter. That's it's tagged with 59.1 and 59.2. That's
No,
I am
it has to
accused
be
number 4.
Coordinate bench had passed some order. 1 minute. I
Yes,
have
my lords.
recorded that coordinate bench has passed some order on the last date.
Yes, my lord, that has
Bipin
WP
Hegde sir
number.
had submitted. Yes,
Yes,
sir.
yes, my lords.
Yes, my lord.
What has happened? The order bandidya.
Bandide, I have forwarded it, my lord. On the last occasion, I had given the copy to your lordships, my lord.
It's WP
then-
number, my lords, 10213 of 2023.
Who appears for the complainant?
My lord, CBI, my lord.
Yes.
No, CBI is not the complainant, my lords. Complaint bank is the
No,
complainant.
if the foundation itself has gone, what remains, sir?
That's right.
My lords, I'll secure my instructions and make my
What
submission.
secure? You have not seen the order of the coordinate bench?
My lords, I
They
have
were
seen,
the
my
parties,
lords,
ma'am.
but it is
They are the
written
parties.
as unrepresented, my lords, whether they have prepared an appeal or whether they have
Unrepresented.
reviewed. How, my lords?
Anyway,
That's-
we
there's
will
no
show
appeal
your,
as
we will
of
show
today.
your name, but follow the order.
Allah, unrepresented in the writ court, my lord. That is what my learned friend is submitting.
ಅದೇ writ court ಗೊತ್ತಿಲ್ಲ. Where is the order, Bipin sir?
My lords, may allow me to share the order, my lords. On
What is the
screen.
order?
Lord, may I read, my lord? Just
The forensic audit report is quashed.
yes, my lord.
Then the substratum goes.
My lords, there's a finding in the judgment, my lords, that
what?
they have given liberty to the bank to reclassify it as account, and then after giving an
Then,
opportunity.
1 minute. If liberty is given to the bank to reclassify the account, then the crime that has sprung because of that will go.
No, my lords.
Then after that you can argue. Yes.
Lords, there's one submission, my lords. In the order, it says after giving an opportunity, they can again reclassify it as fraud.
That is if
My lords,
required.
That's, my lords, that's exactly why I'm saying it is a liberty, my lords.
No, yes. List on 6th February.
My lord, may
As
I
a
make
last chance to,
6th, some difficulties, my lord. Any other?
13th.
Yes, my lord.
List on 13th February
Grateful.
for the hearing.
Yes,
As
ma'am.
a last chance to the respondent to make the submissions.
Very well.
Order on produce.
I will produce. I will, my lord.
Produce that order. Yes.
Yes, my lords, I will do that.
59.1.
Yes, my lords.
Yes. Next.
May I make one more request, my lord?
Yes, Vipin.
My lord, serial number 46 also, your lordships are given 6th as a date, my lord. May I request, my lord, from 13th?
I adu 13th.
46th, my lord.
Yes, sir.
Yes.
Your Lordship, serial number 60. This is that hydro guns.
My lord, appearing for respondent, my lord. Appearing for respondent, my lord.
Interim order
We
is
have
there.
filed an retirement memo, my lord, yesterday.
Thank you, sir. List the matter on 7th March. Interim order.
My lord, we have filed an retirement memo, my lord, yesterday. 60, my lord, for
No
respondent.
problem, sir. Till somebody else comes on record. Don't worry. Yes.
Interim order may be accepted.
Yav retirement memo? One nimsha. Yaar, who are you appearing?
Opposite
For
side.
you are 60, my lord, respondent, my lord.
Respondent. Learned counsel for the respondent has filed a memo for retirement as appearing for the Union of
Kindly
India.
delete.
1 minute,
delete
sir.
my name.
Uta madilva. They filed a memo seeking deletion of the name of the respondent as appearing for the Union of India. In the light of the memo, the respondent is permitted to be the memo for retirement, permitted to retire from the case registry is directed to delete the name of so and so as appearing for the Union of India. Notice be issued to the DSGI Shri Shanti Bhushan. Yes, next.
Your Lordship, if I make a mention, petitioner guy, opposite side is NCB.
Interim order subsisting will continue till the next date of hearing. Ayappa?
The NCB, there are other panel lawyers, Your Lordship.
NCB?
The opposite side is NCB, Nagpur Central Bureau.
It's okay. It's okay.
I
accept notice on that.
All right.
No problem. Shanti Bhushan is here. Don't worry. Yes.
Grateful.
61 KBK Swami.
61, please, my lord, I request for some accommodation.
7th
Learned
March,
senior will
interim
come
order
physically and
subsisting
argue
will
the matter,
continue to the
please.
next date of hearing. Next.
Grateful, my lord.
62 Satish K.
Doping. Just Jagdish. Anti-doping.
Please, my lord. I appeal for the respondent.
Who appears for the respondent? Shanti Bhushan.
Please, my lord. I appeal for that.
Yenaithu.
Lord, as of now, he is permitted. Your lordship had permitted him to play.
That's all right. Objection lack there. We'll pass orders.
Please, my lord.
Yes, heard reserved. Yes.
Please.
But I already filed all the update law. It is there on the file.
Yes, sir. Yes.
63 Naveen Chandra.
My lords, I appear in this matter. My lords, here also this is on a rare disease implementation of the national policy.
Yes,
Let
Shanti
Mr.
Bhushan.
Please, my lord. Please, my lord. My lord, in this case, I need to file my objections. The lordship may give me.
Because this is a policy, yes.
Please, my lord. Please.
Heard the
No, in
learned
fact,
senior
we
counsel.
want prayers that there should be compulsory licensing of the drugs because the
I
drugs
know,
are unaffordable.
Madam, but objections would be required by the state.
No, definitely. But
By the
let
center.
there be a let them file objections. But I want some interim direction. At least it can
Interim
be kept
direction
next
will
week.
dispose it finally once he files his objections. Finally, 2 weeks time I will grant.
Yes, grateful.
Finally, 2 weeks time is granted to the Union of India to file their statement of objections. List the matter on March 7th, 2025 for further hearing. Yes. Objections be filed by then. Next.
64
Madhukar. Idella close ಆಗ್ಬೇಕು. I think you should have lunch and come. 1:45. ಇದು ಮುಗಿಸ್ಬಿಡ್ತೀನಿ ಲಿಸ್ಟ್ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ.
Further hearing matter madam, Bangalore list.
ಬಂದೆ ಮಾಡ್ತೀನಿ. ಕರೆದ್ಬಿಡಿ ಮೇಡಮ್.
65 KBK
ಇದು
Swami.
ಪಾಸ್ ಓವರ್ ಮಾಡಿ.
In 65, please, my lord, the accused is a police sub-inspector who is facing the charges of committing murder of his wife, please, my lord. The police have filed charge sheet.
Further investigation.
Yes, please, my lord. At the hands
CBI
of CBI.
transfer madam. 7th, yes.
The immediate superior has conducted the investigation in this matter and filed a faulty report, please, my lord. I have submitted the
stay ಮಾಡಿದ್ದೀನಲ್ಲ ಅದನ್ನ.
Day of further proceedings has been granted. But in the meantime, please, my lord, the departmental inquiry is taking place on the strength of the defective charge sheet. So that, my lord, ultimately...
I am not saying about the departmental inquiry. List the matter on 7th. Interim order subsisting will continue till the next date of hearing.
Grateful, please, my lord.
Yes.
66 Arun Govindraj.
My lords, I'm appearing for the respond number 2 in 66.
Both sides have exchanged settlement proposals, my lord. I will have a word with my learned friend and
List on
My lords,
7th March.
again, my lords, one submission I want to make. On 16th January, I have made the proposal. If 21 months in one single rupee I have not got for rent. And I've already given a proposal on 16th January, 2 weeks ago itself.
my lord,
And
I have stated in my proposal that I will be paying the rent from April onwards. I have requested for some time. I will be paying rent, my lord, and I will clear all arrears.
List the matter on next week, 6th March. Yes.
Much obliged.
6th February, sorry. Yes.
67, K.R.
I'm
Krishnamurthy.
for the petitioners in all these petitions. It takes some
67
time.
connected matters. I appear for the respondent number 2, my lords.
Sir, we'll hear it there only.
Yes, my lord pleases.
Yes, list the matter on 7th March. Interim order subsisting will continue till the next date of court.
A pleasure.
Appearing for the respondents, my lord, in both.
Lord, there is an interim order, my lord, granted by your lordship.
Interim order will continue, yes.
Lords, let the respondent, my lord, rectify the office objection raised on statement of objection filed by him.
Yavrali, sir.
68.
68.
Please, my lord. I'm appearing for the respondents.
This matter, yes.
My lord, this is the atrocities matter, my lord.
Correct, sir.
Ade. My lord,
There appears to be some office objection, my lord, in the statement of objection filed by him.
Objection serve ಮಾಡಿ Christopher.
Yes, my lord. I copy serve ಮಾಡಿನೇ file ಮಾಡಕ್ಕಾಗುತ್ತೆ ಸ್ವಾಮಿ.
ಅದೇ objection serve ಮಾಡಿಲ್ಲ.
I'll check that.
ನೀವೇನ್ ನಮ್ಗೆ rudimentary things ಹೇಳ್ತಾ ಇದ್ದೀರಾ. ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ರೆ ಫೈಲ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಏನ್ ಬೇಕಾದ್ರೆ ಆಗ್ಬೋದು.
My apologies, my lord. I'll rectify that immediately.
ಆಯ್ತು.
Date may please be fixed, please.
ನಾನು ಇದೇ ಕೋರ್ಟಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದ್ದೀನಿ ಸರ್.
Of course. I had the pleasure, my lord.
Yes. 68.
ಹೌದು.
List the matter on 7th March for further hearing. Yes.
Interim order may be extended.
Interim order subsisting will continue till the next date of hearing.
69, so you
Lords, again, my lords, I appear for the petitioner. My lords, in this, my lords, formally notice may have to be issued, my lords, insofar as R2 is concerned, my lords.
Issue emergent notice to second respondent returnable by 7th March.
PF ಕೊಟ್ಟಿಲ್ಲ.
Please. Interim order. My lords, I have taken.
ಮಾಡಿಲ್ಲ. Yes, ಈಗ ಮಾಡಿದೆ. Yes.
Interim order may be extended.
That will continue. Yes, next 70.
Great.
This is a matter where there's no predicate offense. My lords had passed an interim order granting me protection. But there's one issue here, my lord. My lord, under the garb of investigation, they're calling me every 3 days, my lord, making me sit from 11 to 6 p.m. every single time. Please.
71.
Mayur, pass over. ಮಧ್ಯಾಹ್ನ ಕೇಳ್ತೀವಿ. ಧಾರವಾಡ ಲಿಸ್ಟ್ ತಗೊಂಡ್ಬಿಟ್ಟು ಕೇಳ್ತೀವಿ.
May I make one submission, lordship?
Tahir.
Seal number 35, lordship, I could not follow the list in that point of time, lordship.
No, you said you will raise a challenge to those endorsements that are given to you.
Yes, lordship. They received this, they served the copy to me in the morning itself only, lordship.
ಆಯ್ತು, ಚಾಲೆಂಜ್ ಮಾಡಿ.
I need to see, lordship, I need to make submission that regard. Is it proper or not, lordship?
Odi, sir.
I've given him.
I received in the morning. I received it in the morning only.
I'll
then challenge it. I have posted it next week. Yes.
Lordship, one more submission, lordship.
One more submission, Marvadi, wait, sir.
Lordship, kindly, my clients are saying lordship is passing every day with the flip of the coin. Lordship is passing several orders. For that reason, I have so much pressure, lordship.
Yes, we'll see. Yes.
Small list ಅಲ್ಲಿ ಒಂದೇ ಮ್ಯಾಟರ್ ಇದೆ ಫರ್ದರ್ ಹಿಯರಿಂಗ್.
One list.
This is pertaining to that 4 years inquiry. I have completed even Arbatiya.
ಮಧ್ಯಾಹ್ನ ತಗೊಂಡು ಯಾಕೆ ನೀವು ಹೋಗ್ಬೇಕಾ?
ಇಲ್ಲ, EP I have to commence the arguments in court also.
ತಾರೀಕು ತಗೊಳ್ಳ? ಆಗ್ಬೋದು. List on 6th, you can come online.
Very well.
6th of February, my lords.
ನೀವೇನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು, ಇನ್ನು ಆಗಿದೆಯಲ್ಲ?
ಅಲ್ಲ, ಡೇಟ್ಸ್ ಹೇಳ್ಬಿಡ್ತೀನಿ ಅಷ್ಟೇ ನಾನು. ಬಿಕಾಸ್ ದಟ್ ಲೋಕಾಯುಕ್ತ ವಾಸ್ ನಾಟ್ ಡೂಯಿಂಗ್ PC Act investigations at all at that point of time. Grateful.
6th.
My lord, 6th February.
Yes, sir. 6th February.
Grateful, my lord.
Humble submission, my lord. My lord, as today serial number 12 orders have been passed, my lord. Kindly order for giving a hand copy and also to connect it with one more connected matter in the GMFC court, WP 26650 of
GMFC court ಅಲ್ಲಿ ಕನೆಕ್ಟ್ ಮಾಡಕ್ ನಾನು ಆರ್ಡರ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಮೇಡಮ್. Yes.
The hand copy, my lord.
Serial number 15. Interim order is not showing.
ಯಾವ್ದು 15?
Guest lectures continuation, my lord.
Huh?
Guest lectures continuation.
Wait,
Please.
sir.
ಸರ್ ಇದು ಸಿಟ್ಟಿಂಗ್ ಯಾವಾಗ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ ಸರ್ ಇದು ಸರ್ ಸರ್ ಇದು ಸಿಟ್ಟಿಂಗ್ ಯಾವಾಗ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ ಸರ್ ಇದು
But this is going on. Court is going on. I'm not sitting still.
How do you check that's what I'm doing. ಸರ್ ಇದು ಸಿಟ್ಟಿಂಗ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆಯಾ
Court officer? Court officer?
Sir, they have 64, 64 ಆಮೇಲೆ
64 connected matters.
ಅದೇ that 6 matters.
Yes.
Ah.
My lord, I made a compilation, my lord.
Of what?
because all the judgments, my lord, and subsequent orders. I'll just point out to your lordship, my lord, summary of it.
Vijay Madanlal Chaudhary.
Yes.
2021 SSC online SC 929.
Yes.
Para 467.
Correct.
Adralli clause 5. Predicate offense.
My lord,
Yes.
here, please notice, my lord, in this compilation, your lordship judgment is the first 5, my lord. Thereafter, Supreme
My
Court.
lord, my lord, I appear for the respondents in this case, my lord.
I am not
By
going to grant any time, madam. Yes.
My lord, I'm seeking for a passover, my lord. My senior is on his legs before another court.
I have
Just a
passed it
short
over.
passover.
I have passed it over in the morning. That
My
you
lord,
are
just
not even
short
present.
passover, my
It
lord.
is no short or long yanilla. Yes. Yes, sir. You carry on.
My lord, thereafter, a subsequent complaint was filed. My lord, B report was filed. My lord, objection petition was filed.
Just tell me, my order that quashed the proceedings is affirmed by the apex court
Yes, my lord.
in all these cases.
All these cases. I produced it in the compilation, my lord, so that it will be easier for your lordship to refer to.
E-compilation.
Compilation index nalli. First 5 judgments are your lordships, my lord. Thereafter, the Honorable Supreme Court. Then, my lord, at item 8, my lord, is the second complaint.
There is one judgment of the apex court now, which has reversed my order, which I said Vijay Madanlal Chaudhary, follow Madi, I had quashed it. There, the instance was, he was already convicted. Conviction was set aside in the appellate court. So the Supreme Court says it was a little different. He would rely on that now. It is rendered 2 days ago.
My lord, he is going to rely on a Punjab and Haryana High Court judgment, my lord.
Kodi. Yaudadu?
This is the judgment which they passed it on just now.
Kodi.
My lord, in that FIR, my lord, is pending. That is why.
FIR pending idre nagare.
That is why.
FIR quash agi, it is affirmed by Supreme Court also.
That is why, my lord, Punjab and Haryana High Court.
Courts have easier reason that either the FIR stood quashed on merits or the accused have been acquitted in the predicate offense. The judgment should cover in the event of FIR. No, you highlight ಮಾಡಿದಿರಲ್ಲ ಇಲ್ಲಿ.
Well, that highlighted portion, your lordship may notice, one is Delhi High Court, and where they distinguish it saying that predicate offense has been quashed. So that is not applicable to the facts is what they are saying, man. They rely on one more.
You will highlight ಮಾಡಿರೋದು. The courts have quashed ECIRs only for the reason that either the FIR stood quashed on merits or accused have been acquitted or discharged in the predicate offense. That is what Vijay Madanlal Chaudhary says.
That's all, my lord. That's what has happened here also.
Yes.
That is why they distinguish that judgment.
Yes. ಒಂದು 5 ನಿಮಿಷ ತಾಳಿ.
Please, please.
It will take 2 minutes to decide, but let him come. Yes, Siddharth, why are you waiting? 70.
70 and 71 both of them. Lord, may I just take my lord's order?
Arvind Kamath. Arvind Kamath is ASG.
Please. My lord.
ASG is not there?
The issue here is, my lords had passed 2 orders on 12th of December and 18th of December. My lords may kindly see the 18th order, my lord. This is a case where, my lord, the predicate offense was not against us. Cooperate, my lord. I have gone, my lord. Now, the difficulty here is this, my lord. He's a patient with a history of brain tumor. Now, my lords may kindly take note of this, my lord. 23/1/2025, they call me. Make me sit from 11 o'clock to 6 o'clock. Then, my lord, on 27/1/2025, again, they call me at 11 o'clock. Make me sit till 6 o'clock. Again, my lord, my lords has said, yes, I will cooperate. I have cooperated, my lord. Technically speaking, it still becomes an inquiry because, my lord, I was never an accused in the predicate offense. There is no predicate offense today.
Stop the hands of the
Please, my
idiot.
lord, I understand. But then, my lord, under the garb of investigation, now again they've called me on 7th, my lord. Right from the morning, they make me sit right till 6 o'clock, my lord. They make me, and my lord, I don't want to really disclose as to what they come and tell me. They use, it's all this intimidatory tactics where they make it look like, no, we know what is to be done. All that you won't tell in court. It may not be right for me to say whatever it is. But my lord, now here, my lords may just kindly see, my lords, in my lord's order, 8 subclause 7 was what was relied on, my lord. To say even if the main accused, that is the predicate offense, because in this case, my lord, predicate offense, the mother was the accused. She passed away in 2017. 2018, the entire proceedings are closed. 2024, my lord, the sons are now summoned.
In what crime?
My lord, there is no crime.
Predicate offense ilva.
Illa, 2018 la close agide.
Where is that?
My lords may kindly take. I will take my lords directly to my lord Annexure G, page 159, my lord.
No, which is this crime 205 of 2017?
My lord, crime 205 was against my mother.
What happened?
One is, my lord, again, so both, there were 2 crime numbers, my lord. Both were clubbed together. Investigation was undertaken by Alsur police station. Alsur police station then files a charge sheet only against my mother.
Mother dies.
Mother dies. 2017 only, charge sheet is filed. Stood abated. After that, no proceedings. 2024, my lord, for the first time I get a notice. I go and cooperate. Then, my lord, it follows with a notice to my brother and my wife. In fact, my lord, Parvati Kollur's case is very similar, my lord. May I just pass this on, my lord, because it's very similar to my case. In that, my lord, I'm in fact I'm on a better footing, I would say, my lord. Because in that case, the husband was the main accused in the predicate offense. He passes away. In the PMLA, my lord, as far as ECIR is concerned, PMLA, the husband, wife, and the daughter were made parties. Now, my lord, after the husband passes away, as far as the husband is concerned, PMLA is closed. As far as the wife and the daughter also, it's closed.
Anyway, one password no.
Please,
before I rise.
Please.
Bangalore connect ಮಾಡಿದಿರಲ್ಲ madam. ಇಲ್ಲೇನಾಗಿದೆ? main system ಅಲ್ಲಿ. ಅಲ್ಲಿಲ್ವಾ? ನೀವೇನ್ ನೋಡ್ಬಿಟ್ರೆ ಮತ್ತೆ ನಮಗೆ ಬೇಡ. Santosh Hospital serve ಮಾಡಿದಿರಾ?
Yes, madam.
By hand summons you have taken?
Yes, madam.
Nobody is.
Milords, I appear for Santosh Hospital, Milords.
Using a compilation as directed by your lordships of all the judgments and all the facts relied upon them.
Yes, sir. Santosh Hospital.
Yes, Milords.
You have received the papers?
I have received the papers, Milords. I filed your.
Where are now, according to law, you have to have two samples, one to be sent to the FSL, one with you. All right.
Yes, Milords.
Where are the samples that are with you now? Produce everything.
I will get the instructions and I will submit, Milords.
Samples of that day preserved in terms of law.
Excess of what utilized for testing.
The excess of.
Even the one sample which they retain.
Milords, I understand that, my lords, but the entire concept of it being retested, my lords, can only be done at the instance of the accused.
That I will answer. Let me take care of Santosh Hospital.
Kindly.
Yes. This court on 23/1/2025 had passed the following order. This court directed impleadment of Santosh Hospital as a necessary party to the proceedings. The reason for such direction was that a shoddy sampling done by the hospital, not in one case, but plethora of cases. On the allegation that shoddy so-and-so is done, not in one case, but plethora of cases. A perusal at the papers of papers appended to the petition somewhat vindicate the allegation of Mayur, the learned counsel appearing for the petitioner. Therefore, Santosh Hospital shall on the next date produce the second set of sample that is to be preserved by the hospital in terms of law in excess of what is sent to the FSL for its testing, failing which it would become a case where adverse inference could be drawn against the hospital for undertaking such shoddy sampling in not this case, but every case, as these are offenses that are alleged to be punishable under the Narcotic Drugs and Psychotropic Substances Act, which have serious consequences on the petitioners, on the accused, whoever it is. Therefore, the hospital must come out clean by producing such material that is to substantiate the allegations made by the petitioners in the petition.
Apologies, my lord. Only one statement, my lord, about the FSL. It has never been forwarded to FSL.
The learned counsel for the petitioner would now submit that Santosh Hospital has never forwarded the sample to the FSL, as there is no report of the FSL of any forwardal of a sample from Santosh Hospital to the FSL. Therefore, whatever samples that are available that is collected on the day of the incident, shall be produced before this court along with supporting documents.
Lord, at the risk of repetition once again, my lords, they themselves test. Other than the urine that is tested by them, they should have had another sample with them. That is not maintained. That is not.
And the remainings of the first sample which they utilized, that also Lordship direct them to.
Yes, that will,
Status of
will
that.
correct. Yes.
Because that is where.
So and so by the records, they be placed before this court by the next date of hearing. That's why I told you, come online. Why do you want to come with this?
My lords, problem is, my lords, this morning when I was appearing before Justice Krishna Kumar through VC, my lord, there were so many glitches, my lord, my submissions were not even heard.
Interim order ಸಿಕ್ಲಿಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, interim order ನನ್ನ ಮೇಲೆ ಇತ್ತು. It was Sadesh Chowda sir was appearing on behalf of another petitioner.
No glitch will stop.
My lord, it's an honor to appear before your lordships, my lord.
That's all right.
Rather come there.
It's a pleasure to hear you also.
Grateful. Grateful.
That's the reason I'm holding this.
Grateful.
To do something in this. Yes. We'll list it on 13th.
6th, my lord's kind.
6th or 13th anyway. Yes.
Milords, may I request on 13th minutes? 13th minutes. 13th minutes.
ಎಲ್ಲ records create ಮಾಡಬೇಡಿ.
Swami, ಇಲ್ಲ Swami.
I have some inconvenience on 13th. That is the reason.
12th ಬೇಕಾ?
12th, yes, my lord.
List on 12th. You appear. List on 12th.
Much obliged.
At 2:30 p.m.
Much
obliged.
His name may be shown in the court.
Learned counsel ಬರ್ಕೊಳ್ಳಿ. This court had directed, mail ಬರ್ಕೊಂಬಿಡಿ madam first, had directed service of notice by way of hand summons to Santosh Hospital, which was newly pleaded. Learned counsel Vivekanand has entered appearance for Santosh Hospital. The registry to print the name of Vivekanand is appearing for respondent number 2. Yes.
All copies are furnished to them, also. Everything.
Swami, I have received everything. Much
obliged.
Yes, Madhukar.
Yes, my lord. The question is that, my lord, whether ECIR has to be quashed is the question, my lord.
Yes, sir.
Yes, my lord. In this particular case, my lord, certain proceedings under section 62, subsection 2 of the PMLA Act has been shared with other agencies, my lord. And under those circumstances, my submission is that, my lord, ECIR cannot be quashed. And more particularly, my lord.
ಒಂದು ಹೇಳ್ಬಿಡಿ. Do you have independent existence?
My lord,
please tell me, do you have independent existence or you fall back upon a predicate offense that is registered? If
no, I cannot.
If predicate offense is the foundation, you are the superstructure. Now the foundation has gone. Supreme Court affirms that the superstructure should tumble down. Where are you staying?
My lord, my submission is that, my lord, in the light of the Vijay Madan Lal Chaudhary judgment, paragraph number 282, my lord, the section 66 has been considered.
Yes, sir.
With reference to section 66, after considering section 66, one can share the information and also request that particular power which is available under section
You have
66.
shared information with whom, sir?
The agencies, my lord, I can
Which
explain
agency,
to.
sir?
The election commission is the one agency, my lord. Income tax department is the another agency, my lord. Where
right.
all the offense, 3 or 4 agencies.
ಅವ್ರು ಮಾಡ್ಕೊಂತಾರೆ ಬಿಡಿ, ಶೇರ್ ಮಾಡಿದ್ರೆ ಅವ್ರು ಮಾಡ್ಕೊಂತಾರೆ, ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ. ED proceedings cannot continue.
My submission is that, my lord, once the schedule offense goes, I cannot initiate any proceedings pursuant to the schedule offense under the PMLA.
Correct.
Except section 66. Except section 66.
That is a proceeding that is independent cause of action. They will challenge it if need arises.
Yes, my lord. In such a circumstances, if at all they show any document, any proceedings subsequent to that of the quashing of the schedule offense, if we have taken any proceedings or if there is any provisional attachment order which has been earlier issued and if it is still alive and if it is still in vogue, my lord, let them show it. Then, my lord, my submission is that, my lord, the Vijay Madan Lal Chaudhary, whatever the observation made by the Supreme Court holds good.
No,
But my submission is that
I'm only saying, when
yes,
you have
my lord.
lost your very existence, how are you
Yes, my
asking
lord.
all this?
My lord, I am not asking anything, my lord. I am not
Then
asking.
what?
I am just sharing the information. The idea of filing of
You
this.
have shared the information. They will ask. Leave it.
Yes, my lord. Now my submission is that in the guise of,
Why is the ED worried? They will ask.
now the question is
Income
they are
tax will ask. The election commission will ask. They will issue
Yes, ma'am.
notices to them. Why is ED worried?
My submission is that they are seeking for the quashing of the ECIR. If the
Very
ECIR
much,
is
sir. You have shared information. They will initiate separate proceedings.
my submission is that, my lord,
ECIR cannot remain, sir.
ECIR is an internal document, my lord, and that particular
Sir,
internal document,
whether it is an internal document or a public document is a different thing. It takes birth only after the predicate offense getting registered.
Yes,
Predicate offense is no more in existence. How can this, which has taken birth because of that? That is why umbilical cord.
No. The proceedings pursuant to the schedule offense would not remain, my lord.
Correct.
But ECIR would remain. The reason is that the object of this particular act is not just the punishing the person who has committed the offense. It is the object is that prevention of this particular money laundering. That being the object, my lord, that particular section 282 as well as other section. I am also referring to one more judgment, my lord, where the Punjab Haryana court was requested to read down section 66 subsection 2, and on that basis they sought for the discontinuation of the proceedings. Then the Punjab and Haryana division bench, considering the section 66(2) as well as the various other judgment of the Supreme Court.
Supreme Court challenge madilva Punjab and Haryana.
We found that it was not there.
Okay. Yes, we will answer it.
Hope my lord says the IREO Private Limited versus Union of India, my lord.
Yes, sir, I have it.
Yes, my lord. I request my lords to kindly take the page number 1, my lord, where the prayer has been extracted. The prayer, that is the request for the reading down section 66(2), my lord. Then the subsections, the prayer number B, my lord. No power or authority vest with the director or so and so against any person, entity as contemplated under section so and so. Any such would tantamount to blatant illegality, arbitrariness, and thus unconstitutional. Then set aside the quash the impugned communication dated. They sought for the quashing of the communication.
Yes, sir. What have you to say?
Sorry, my lord, I can't hear my lord.
I have not challenged that provision. Section 66, my lord. My lord, if they have advanced it, my lord, to the agencies, as my learned
For those agencies to look into.
Yes, my lord, that's all. I'll report to that.
Yes.
Now the question is that, my lord, that particular agency we have communicated pursuant to the ECIR which we have registered. Without registration of the ECIR, we cannot do it. And for that reason only, my lord, we are able to.
No, your intimation ceases once it has left you.
Yes, my lord, but that does not mean that ECIR has to be quashed. In this particular case, my lord,
It has to go.
My lord, my submission is that, my lord, I may be permitted to convince my lord with reference to the other judgments also, my lord. The reason is that, my lord, this is a special provision which is available in this particular act. After considering this particular section only, my lord,
Section
the
66 you
ECIR
have
has
to-
been considered as an
you
internal
have to
document.
search on section 66 and submit on the next date. Heard the learned senior counsel M.V. Sheshachala appearing for the petitioner. The issue in the list is whether the proceedings under the under the Prevention of Money Laundering Act 2002 should be permitted to be continued, notwithstanding the fact that the predicate offense, i.e. the offenses under the IPC, have stood obliterated. And the obliteration of the offenses under the IPC has, and the SLP filed against the obliteration of the offenses under the IPC has been turned down by the apex court. The learned senior counsel would take this court through plethora of judgments rendered by this court, all relying upon the judgment of the apex court in the case of Vijay Madanlal Chaudhary versus so-and-so, 2021 SEC Online SC, page 929, where the apex court holds that once the predicate offense goes, the offense under the alleged offenses under the Prevention of Money Laundering Act would also automatically go. The learned counsel Madhukar Deshpande seeks to distinguish the judgments rendered on the score that the Enforcement Directorate has furnished information to various other agencies under Section 66 of the PMLA, and the other agencies are entitled to inquire, for which ECIR must be kept in existence. The learned senior counsel would dispute the position. List the matter on 13th birthday. List the matter on.
May I make one submission, my lord? May I make one submission, my lord? The copy which has been served on me, my lord, on the 23rd January 2025, there are no judgment, my lord, of the Supreme Court or any other High Court dealing with this particular situation. It is only with reference to schedule offense and inter se party dispute, my lord.
Ade, sir.
Sorry.
Yes. So and so. They list the matter on 13th at 2:30 p.m. Intermorta subsisting would continue till the next date of hearing. We'll answer this issue, Madhukar.
Yes, my lord. Yes, my lord. The reason is that, my lord, sorry, my lord. The reason is that it is considered as an internal document so that the prevention of money laundering should continue for that reason. Of course, we will not have the power to arrest. We will not have the power to confiscate. We cannot have any power. But only that particular reference should be there. The ECR should be there. That is the information report, so that other proceedings can continue, my lord, for that reason.
You mean to say toothless tiger and will then continue still?
The reason is that, my lord, the object is not to punish only. The prevention of money laundering is also the object for that reason.
All right. Yes. List on 13th at 2:30 p.m. Yes.
Much obliged.
Madhukar, idu innondu. Siddharth Suman.
My lord, ಏನು the parties?
At serial number 70, ಅಲ್ಲ?
70, 70.
Serial number 70, ನಾನಿದ್ದೀನ? My lord, my name is not my.
Your name is not there?
Not learned ASG's name is there.
Arvind Kamath sir there. You are appearing or learned ASG is appearing?
My lord, if the party name, sorry, my lord, I am requesting the court, sorry, man. Sorry,
Mahendra Kumar Gupta.
What is this? Mahendra Kumar.
My lord, my lord, I am appearing, but I was not aware of the listing of this matter, my lord. Our name is not being shown, my lord. I request the register.
But the allegation is that you are troubling them, calling them every day. So don't do that till the next date.
Please, my lord.
List the
My lord, that is not the allegation, my lord. That is the
inway.
No, my lord. I have, my lord, in this particular case, my lord, kindly have it after half an hour, my lord. I will get the file. I will, what all has happened, I will explain, my lord. I was not aware of the name of the party, my lord, for that reason.
All right, yes.
It is a serious case, my lord, for that reason.
All right. Anyway, I have protected you.
My lord, insofar as the investigation is concerned, my lord, at least if my lord's, at least
No, no, my
7th,
lord,
if my
he
lord's
has-
is there physically in
has-
Bangalore, my lords may have it on 7th itself.
No,
7th
no,
is
no,
when
my
they've
lord, he
called him
has
also.
appeared.
At least,
He
my
has
lord, till
appeared.
7th,
He
I've
has. He is
cooperated.
not cooperating at
I'll
all.
take it on-
He's
one
not
minute,
at all
sir.
cooperating, my lord.
Wait, sir. I'll take it on 6th.
6th, my lord, there's a slight inconvenience. I'm not there.
I said
7th, my
7th.
lord, 7th, because till 7th, my lord, because it's on
No, no,
7th.
my lord, he is
I'm
not at all
saying
cooperating, my
anything.
lord.
Not staying, my
Earlier
lord.
order I have said.
At least let them not precipitate till 7th, my lord,
Hey,
because
No, no, my lord, he is not
my
at
lord,
all
that is no
cooperating.
coercive action. But now on 7th, I have to still go there and sit from 11 o'clock to 6
No, he
o'clock.
has to, my lord.
Don't
He is
worry
not at all
about that.
cooperating, my lord.
I'm not, I have gone on every single date I've gone, my lord.
Versus allegation.
Please, I
He
understand.
says you're not
I
cooperating.
understand, my lord. Let them show one document to say I've not gone there, my lord. Every single date I've gone. And
No,
they've
no,
called
I
me
will.
3 dates
explain. In a
continuously.
sealed cover, I will produce, my lord, all the relevant documents. That
Let them at least show
unfortunately,
prima
I am not.
facie,
I am not
because
having the file, my lord.
my lords will appreciate that they have to at least show a reasonable cause, because I've already gone 4 times. Let them show why I'm required there again.
Based on 7th, the allegation of the petitioner is that the petitioner is repeatedly called by the enforcement directorate now 4 times in a row and no statement is taken.
Statement is taken, but he's made to sit for 7 hours, my lord, straight.
No, no,
Is
no.
called and no called for nothing and is made to sit in the office from morning till evening. The learned counsel Madhukar Deshpande would refute the submission contending that the petitioner has not cooperated with the investigation at all. Therefore, list the matter on 7th. The counsel to produce Madhukar Deshpande to place on record the appearances of the petitioner before the investigating officer, before the ED by the next date.
Look,
The
7th is
protective orders. The protective orders that are pending, that are in subsistence shall continue till the next date of hearing.
May I seek an adjournment on 7th, at least before the ED?
It is open to the petitioner to seek postponement of the date of 7th, postponement of the next ensuing date for appearance, i.e. the 7th, on the ground, on the score that the matter is being heard on the said date.
Please. It may be wrong to say if he's been called for nothing. He's there, he's made to sit there, he's made to give certain statements. Then they call him back. I wouldn't say. Madila ante helala, my lord, because that would be wrong on my part. What they do is something else, my lord. They call him for something else, they do something else and send him back.
What is that something else?
My lord, no, again, the way if you have to call it an investigation, we call it an investigation.
Right.
Please.
My
So,
lord, registry
because
may
they
be
should not
directed
take,
to show my
they
name,
should
my
not
lord,
take
because
exception
that
to
is
the word
difficulty,
nothing.
my lord, I'm finding it.
So, please, my lord.
Yeah.
No, because tomorrow the learned ASG would come and say, no, he's saying nothing is done. That should not be a situation.
Madhukar is appearing.
My lord, my
the
name is
Lord-
required to be shown, my lord. Registry may be
Registry
directed to show
print
my
the name of Madhukar Deshpande as appearing for the respondent in place of Arvind Kamath ASG. Yes.
Please. Oblige.
Yes, Madhu on this
7th, my lords is physically there in Bangalore, my lord.
No, you should be physically there here, sir. Why should I be there?
I was under the impression my lords is there.
No.
And then I'm coming on 20th, my lord, my lords may
No, alivariga agala. 7th you have to, then we'll post it on 13th. You're not there?
My lord, 13th, because we had requested 20th, because only thing is.
Kumbh Mela na?
Illa, my lord, I'm here itself.
My lord, it's a serious case, my lord. He is not at all cooperating. We are not further proceed with the investigation at all. In fact, now I have to.
6th or 7th?
Then, my lord, then my lord, 13th, I'll take a chance, my lord.
No, list on 7th.
My lord, because
Appear online, no problem.
Please, that's the case, my lord.
I'm not asking you to appear here, appear online. Yes.
It's more impactful here, my lord, also is what.
Whatever.
Please, my lord. Please, oblige.
ಕೊಡ್ಬೇಕಾದ್ರೆ ಮಾತ್ರ glitch ಆಗುತ್ತೆ ಕೇಳಲ್ಲ ನನಗೆ ಆನ್ಲೈನ್ ಅಪಿಯರ್ ಆದಾಗ.
If it is on vConsole, that's the problem, my lord. Zoom is fine.
So that's why I've removed vConsole and
Please.
Yes.
Oblige, my lord.
Much obliged.
ಇನ್ನೇನು ಉಳಿದಿದೆ ಮೇಡಮ್?